ಮೇಡಮ್ ನೆನ್ನೆ ಒಂದು ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ದೆ, ವಿಡ್ರಾಲ್ ಪೋಸ್ಟೇ ಮಾಡಿಲ್ಲ. 2083/2023 ಬಂದೇ ಇಲ್ಲಲ್ಲ. ಇನ್ನೊಂದು ಮೆಮೊ ಕೊಡ್ತೀನಿ ಈಗ ಹೇಳ್ಬಿಟ್ಟಷ್ಟೇ. ಅದೇ ಮಾಡ್ಬೇಕೀಗ. ಪೆಂಡಿಂಗ್. ನನಗೆ ಸುಮ್ಮನೆ ಅಲಿಗೇಷನ್ಸ್ ಮಾಡೋದು ಬೇಡ, ನಾವು ಸ್ಟಾಫ್ಗೆ ಯಾಕೆ ಅಂತೇಳಿ. ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ, ವಿಡ್ರಾ ಮಾಡಲಿಕ್ಕೆ. ಹೌದು, KSFC RSC ಬರುತ್ತೆ ಆಬ್ವಿಯಸ್. (2083/2023) ಆಯ್ತಾಯ್ತು, ನೋ ಪ್ರಾಬ್ಲಮ್. 23. 23.
On submission, my lord, WB 5667 2025. My lord, this is a batch subvention scheme EMI matters. There are 38 matters connected to this. My lord, they are pending for final hearing since December 2025. The urgency here is, my lord, there's an IO extended to 32 other matters in the same connected matters. Even though IO was extended, it's not been reflected in the order copy, due to which the banks has been harassing the petitioner here, my lord, to pay the EMIs. The Honorable Court has been intervened and stopped the payment of EMIs, my lord. Even though the same has been done, that's not being reflected in the order copy, and the banks have been harassing the petitioners.
Which order copy you're talking about?
IO, my lord. There's an IO.
Was it when the matter has come up?
17/12/2025, my lord.
Then that it has come up before me.
Yes, my lord.
Then
Even though IO was extended, it's not being reflected in the order copy online, my lord. That's why banks have been like forcing the petitioners to pay the EMI even after the.
Which is the bank?
Union Bank, my lord. 38 matters are there, my lord, connected.
In that Union Bank, who appears?
My lord, I'm not aware who is appearing for Union Bank, my lord.
Advocate.
I'm not aware of it, my lord.
No, they wouldn't be doing, because they know that the matter is I've taken the entire batch. That's not only, it's not 20 matters.
38 matters are there.
No, more than that. No, more than 90, 100 matters are there.
Yes,
I'll be giving a date on next week someday.
yes, my lord.
Take it.
My lord,
Fresh matter, my lords.
in this matter, the
Fresh
amount,
matter, my
connected
lords.
Which matters will come? If not coming, please tell the court officer after 24 hours. Yes.
One matter for pending, my lord, the matter pertains to PDS, my lord. But since, my lord, some of the, my lord, the women who established Sangha, my lord, three Sangha, they filed an
Here is a
application.
writ petition.
But please, my lord, 2023, my lord, any date, my lord, at least, my lord, last month
Convenient to
of
the
last week, my lord.
Yes.
my
Why are you moving the memo?
Section 14, they are not disposing of trial court.
But I'm making very clear to the bank, once I call for a report,
Yes,
if
madam.
it is because of your lapses,
No, madam.
yesterday I have dismissed one. Tomorrow, now your matter, I'll dismiss it with costs.
Yes.
Take it tomorrow.
my lords, in this matter, amount is ready, my lords. I was directed to pay a sum of rupees 1,81 lakh, my lords, before 28th February, my lords. Now there is a delay of 2 weeks, my lord. Thereafter, I approached the bank, they are not receiving the amount. Now the DD is ready, my lords.
My lords, I apologize. Fresh matter, my lords. I've been trying since 3 days. It's not getting listed.
Look at it, why it is not? In my court, every matter that is numbered will come, because I'm not restricting the list. Only thing is you have to comply with the office objection.
Yes, madam.
Otherwise it won't come. Yes.
Yes, on some petitioner not complied the interim order, my lord. They have obtained in the year, in the month of October, my lord. Till today, they have not complied.
DRT matter,
Please, Kendra, ma'am.
next week. Just look at it, basing on the matters, equally distributed.
Lordship, MVC matter 2004, pending matter 2014, any date can be fixed.
2000,
matter, my lord, MFA.
DRT matter.
No, ma'am. MVC matter, MFA, my lord.
No. On MFA date, it will come. Take it. From the old, it should be listed.
My lords, item 17 of today's list.
Yes.
Page wise adjournment, list number 1, page number 4, page number 11, 12, page number 5, 13 to 15.
My lord, scene number 13, my lord, I am for respondent number 2. Inform the petitioner, my lord, my lord, may kindly have it next week. The single window committee meeting has not yet held, my lord. Its date is yet to be fixed. So, my lord, may kindly have.
Appear for?
I am for respondent number 2, KIDB, my lord. So the single window committee was supposed to held on.
Inform the petitioners council.
Please, my lord, we have informed the petitioners.
This is matter after vacation. At the request of learned counsel, the respondent, he submitted that. It's already informed to the counsel for the petitioner, and he has no objection. Yes,
Page
look
number
at it,
6.
any interim order, extend, yes.
Page number 6, cell number 16 to 20.
My lords, item number 17, my lords, I'm appearing for the petitioners, my lords. I seek a short accommodation, my lords. The bank has given me instructions. They are engaging a senior counsel. I already informed the respondents. They are also here, my lords. Just 3 weeks' time, I would request, my lords.
This is after vacation.
My lord,
Obliged.
serial number 18, my lords.
At the request of learned counsel, the petition, yes.
Serial number 18, my lords. The advocate on record is unwell, my lord. He is hospitalized, my lords. I am trying to call the respondent, my lords.
Respondent back in this matter. Filed application for vacating of interim order.
Is this matter on next Tuesday?
Interim order may kindly be extended, my lord.
And no further adjournments.
Grateful, my lords.
Page number 7, cell number 21 to 26. Page number 8, 27 to 32.
Serial number 27, my lord. I am for petitioning this. Pray for a short accommodation as senior need to take his father for a chemotherapy today. So because of that, my lord.
Inform the other side.
Yes, my lord. Senior is already.
Is this matter after vacation?
Much of this.
Look at it if interim order is there extra. Yes.
Page number 9, cell number 33 to 38. Page number 10, 39 to 43.
Serial number 41, your lordship. And for the appellant, I seek for a short.
No, I'll not be taking up any of the MFAs. All MFAs that are listed, give a date for that.
Page number 11.
Yes.
12, page number 12, cell number 45 to 46.
My lord, serial number 45, I'm for the petitioner. I have filed a NOC Vakalat yesterday. We have yet to receive the documents, so we have filed a, so
That your
2 weeks
lordship
time may be
disposed
given.
of. That's not the concern of the court. Now your client keep on changing the advocates, 21 matter just before the hearing, if he gives you wakalat, that's not a ground to adjourn the
My
matter.
lord, 1 week
That's
time
how
may
it
be
is
given.
parted.
My lord, please, we have received NOC Vakalat yesterday.
Let
1
the
week
interim
time.
order be vacated, my lords.
My lord, 1 week time may be given. We have filed certified copies, so 1 week.
22 matter, where is the, which 24?
21, my lords.
It's the
connected
same matter where my lord council made a
40.
This is
45
40?
and
45, my
45.1.
lords. They have challenged the wives of the Sarfezi Act. and
Last week also
action under
same
MSN.
submission is made by the Siri R.
My lord, we have received the NOC yesterday.
My lords, yesterday is, you sought for the NOC and we have given the NOC, my lords.
In fact, we have placed our my lord written notes of argument also in this matter.
Pleadings are
This
complete.
matter
my
heard
lords.
at length.
No, earlier advocate, he has dragged on the matter on something or the other. Now the second round. So it shows the intention of the client. What he wants. And basing on his undertaking, you are enjoying the interim order.
My lord, 1 week.
Monday, no further time.
Instead of Monday, my lord, Wednesday, Monday, I have some.
Wednesday.
I'll be not in.
My
Great.
lord, interim order to be extended. My-
May be vacated.
And also in
Matter,
45.1.
this is matter on Wednesday. Matter will not, no further adjournments will be granted. If the petitioner wants adjournment, writ petition will be dismissed on the ground.
Grateful.
My
List
lord,
on
serial number
Wednesday.
45.1 also. 45 and.
On 45.1 also will go.
Okay.
Yes.
For orders matter, cell number 1. Mr. Jagan Mohan.
1 week time may be granted for taking steps to R1 million.
On furnishing,
R2 is the SCST corporation, is it a government undertaking?
R2
Is a SCST corporation, government undertaking, may be permitted to copy to government.
is Mr. A.
CST corporation. Special
Take
advocate is
note,
there, my lord. P. Jagdish is there, my lord. Special
so the
advocate.
R,
P. Jagdish.
C. Jagdish.
it is R2 or
R2, respondent number
R2,
2.
Mr. So-and-so is directed to take notice. Then what about R1?
1 week time may be granted.
R1 is who?
R1 is a driver of the vehicle, which is not in
The
accident.
petition shall pay the process as far as R1 is concerned within a week, or else the appeal shall stand dismissed. Yes.
Then, Padmi Shastri.
Read the letter. The MFA. Setting a statement and award passed to the tribunal. Dated 27/2024. Court. Before the tribunal on 15/12/2025. The court to dispose of the matter within 2 months. and a judge stating several reasons why the same was not disposed of and sought for 6 months' time, considering the letter dated so and so. 12/3/2026. Another 6 months' time granted for disposal of the embassy. No further time will be granted. Yes.
There is a 16. They are seeking to complete the process of inquiry and submit a charge sheet, my lord. Investigation is completed, my lord, and charge sheet filed,
Page number,
page number 16, my lord. To complete the process of inquiry and submit
writ
a
of
charge.
mandamus 1 to 4 to complete the process of inquiry. Charge sheet is filed.
Charge sheet is filed, my
What
lord.
is the number?
On 8, CC number 15558 of 22.
This is number 1,
15558 of 22.
20
22, my lord.
on the file of.
My lord, that is.
You please ask your officers to give that information.
I mean,
Charge sheet will not be somewhere.
yes, my lord.
The present writ petition is filed. Sing the following prayer. Learned HCGP appearing on behalf of the respondent submits that. And nothing survives for consideration in this writ petition as the police have conducted the investigation and filed the charge sheet. The same is numbered as CC number 1555 of
15558,
2022.
my lord. 15558.
1558.
Yes, my lord.
1558 of 2022. Considering the submission of the land counsel for the petition, the land counsel for the respondent, learned HCGP, the petition is disposed of.
Bill number 4.
Memo for withdrawal. Memo is filed seeking to withdraw the petition, dismissed as withdrawn. Yes, fine.
Bill number 5.
Grateful.
The petitioner.
Bill number 5.
My lord, court notice was issued to respond number 3 because their earlier advocate passed away. Now the postal
It is
shara
served?
says, no, my lord, it has not been
Court
served.
notice issued to R3, but on postal verification, no status of delivered is shown.
Yes, my lord, it's Jilla Panchayat. There is one more advocate, Mr. MS Devraj, who appears for Jilla Panchayat. I may be permitted to serve.
1 minute.
Ramnagar Jilla.
Which respondent, now the notice is ordered?
Respond number 3, my lords.
Chief Executive Officer, Ramnagar
Ramnagar
Jilla
Jilla
Panchayat. Who appears?
Mr. MS Devraj, my lords. is the panel.
Print the name of Mr. So-and-so. This is matter next week.
I may be permitted to serve the copy, my lord. I may be permitted to serve the copy.
Land counsel the petitions of the copy of the writ petition. Yes, 6.
Bill number 6. Kavita D.
No representation for dismissal on Monday.
Bill number 7.
So far as service of notice, my lord, is concerned, R2, my lord, we have paid the process. There is a delay, my lord, of 1
Let's
week.
hear the writ petition, what it is.
I present R1. There is a delay, my lord, of 1 week in payment of the process. Registry, my lord, has not issued the notice. At
So
1
let's
week
see,
delay.
what is the writ petition
My lord,
about?
writ petition, I'll come back to a writ petition, my lord. The challenge, my lord, is with regard to the notice that has been issued. So far as the petitioner is concerned, my lord, the petitioner is neither a borrower nor a surety, my lord, to the loan.
So you're questioning the proceedings under
Please,
section 14.
please. Now, what has
So this
happened,
is
my
for
lord?
taking possession of the petition.
Please.
So what is the nature of the property?
The nature of the property, my lord, is residential house.
When did you purchase it?
My lord, I had purchased in the year 2016. My lord, my
Date of the sale date,
date of the sale date is 28/9/2016.
9/2016.
2016.
Yes,
The third and fourth respondent, my lord, claimed to be an agreement of sale holder. Their vendors, my lord, being the second respondent. Now, these third and fourth respondents will not
please-
contract a loan with the
please
bank.
come to the cost rate.
Please. The first respondent, my lord, is the financial institution.
Now, it is L&T Finance Services.
Please. L&T Finance Service, this, my lord, financial institution had, my lord, given loan to the third and fourth respondent.
Now, this against MS L&T Finance Services, which is a private finance company, writ petition is not maintainable. In the light of the Supreme Court judgment.
Supreme Court judgment.
Go before the tribunal. You have an interim order?
I have an interim order.
It will continue for 4 weeks. The writ petition is filed against seeking the following prayer. The respondent is Mrs. L&T Finance Services Limited. In the light of the law laid down in Vishabharati, so and so, the writ petition against a private finance company is not maintainable. However, a coordinate bench of this court has granted an interim order. When was the interim order?
Interim order 15/4/2024.
15/4.
4/2024.
15/4/2024. No. 15/4/2024 is not the interim order. It only says, learn counts for the petition submitted, office objections are complied with.
18/4.
Office to verify and post the matter.
18/4.
Ah.
Some confusion, please.
The petitioner, a coordinate bench of this court has granted an interim order on 18/4/2024. In that view of the matter, this court has passed the following order. Writ petition is disposed of, giving liberty to the petitioner to avail the remedy before the DRT. As the petitioner has the benefit of the interim order from 18/4/2024, the respondents shall not take any coercive, the same shall continue for a period of 4 weeks.
Section 14, my lord.
Huh?
Section 14.
That time, petitioner shall have the benefit of section 14 of the limitation.
Petition number 8, only party in PS.
Who moved the memo?
One.
Who moved the memo?
ನಾವು ಮೂವ್ ಮಾಡಿದ್ದ ಮೆಮೊ ನಾವು ಮೂವ್ ಮಾಡಿದ್ದೆ ಸರ್
Look at it, who moved?
ಮೆಮೊ ಯಾರು ಮೂವ್ ಮಾಡಿದ್ದು
Memo is filed by me, my lord, because my lord, the DRT had dismissed the application filed by the petitioner, my lord. He has filed application before the DRT for leading the evidence before the OA number 1973 of 2007. My lord, already, my lord, the DRT has given more than 4 times, my lord, for leading the, he not appeared before the DRT, and subsequently, my lord, he has filed application for recalling the order. That application was dismissed by the DRT, my lord. He has already sufficient opportunity was given by.
No, what is impugned in this?
See, my lord, page
My
number
lord.
123.
What is impugned in this writ petition?
Kindly see, my lord, page number 123.
My lord, the petitioner is arraigned as defendant number 7 in the DRT proceeding, my lord. The dispute arises out of.
Passing the order dated 22/12/2023.
Please, my lord.
Passed in IA number 1992 of 2023. Please come to that order. Where is it, page number?
My lord, 123.
Page number?
123, my lord.
Let's read the order.
Heard and perused the records of case papers proceeding. On examination of the records and proceeding sheet of the case, it is clear that the defendant number 7 has filed wakalat on 18/3/2019 and has filed the written statement on 25/7/2019 along with the present IA number 1992 of 2023, recalling the order and permit him to leave the evidence. In view of the above and for the reasons stated above, the IA number stands dismissed. My lord, there were a total of 8 defendants and 15 IAs filed. And there were multiple changing of stage in the case.
One
my
minute.
lord.
So what happened according to you?
LEC para number 8
This
of the
order is dated 22/12/2023.
That's correct.
After that, what happened?
LEC para number 8 of the order, my lord, in page number 123. Para number 8. The applicant bank and despite sufficient funds provided by the respondent number 7 to reduce the evidence of the.
Had that application is allowed, by this time your bank could have got the relief.
Please.
Unnecessarily from the last 2 years, it's pending here.
The submission before this one court, my lord, already the.
No,
defendant-
because the defendant has filed an application, the applicant has to file his objections, can't be the approach of the bank. You want your money, and if this application is allowed in the year 2023, by this time everything would have concluded.
My lord, otherwise, my lord, let them defendant number 7. The petitioner has fixed the date, my lord, next is the.
Stay is granted in this.
Yes.
Please, my lord. Stay.
We'll permit them, we'll allow this application. Please come.
My lord, that date is the
Yes,
30th, my lord. Let them, my lord, the defendant, the petitioner.
I'll
has to
fix a
read
time
evidence.
frame.
Please, my lord.
I'll fix a time frame.
Yes, ma'am.
Yes. The present writ petition is filed, seeking the following relief. The petitioner is defendant number 7. Your defendant number?
7.
7?
Please, my lord.
Defendant number 7 in the OA. The facts of the case are the which respondent is the bank?
R1, my lord.
The first respondent corporation has, from the first respondent corporation, the loan was availed by which respondent?
R2, my lord.
The defendants 1 to 7, 1 to 6, after the sanction of the term loan, have jointly executed a deed of guarantee dated 19 to 2016. Primary security of the land allotted by the defendant number 7. The after releasing the amount, after releasing the amount to the defendant number 1, out of which a sum of rupees 5 crore, 12 lakhs was released to defendant number 7 through RTGS, through Mrs. Canara Bank, Jayanagar, towards plot allotted to defendant number 1, and for issuer received for rupees 5 crore, 12 lakhs, and are also requested to send lease cum sale agreement executed by defendant number 7 to the applicant. The defendant number 7 has executed receipt dated 25 to 2016 for having received through RTGS for lease of plots allotted to defendant number 1. The defendant number 7 has executed the MOU that it is agreed between KIA-DB and KSFC that if KIA-DB cancel the allotment of original allottee, in such cases, KSFC is entitled to take over land and sell the same from recovery of its dues. The said MOU is that's signed by the director, KIA-DB and KSFC. The defendants 1 to 6 have not implemented the project and have not repaid the loan. Hence, the bank has issued, the corporation, financial corporation has issued notices to defendants number 1 to 6 for the repayment of the loan amount, and the defendant number 1 has obtained bank guarantee for rupees 5 crores, which is valid till 30/11/2019. On the light of the default, the corporation has filed OA before the tribunal, and the petitioner before this court is arraigned as defendant number 7. When the evidence evidence of the defendant is closed, number 7 is closed on 6/9/2023. Thereafter, I number 1992 of 2023 is filed by the petitioner seeking to reopen the case and permit the defendant to lead his evidence that came to be dismissed by order impugned. Next paragraph. The tribunal, while dismissing the application, has observed that on examination of the records and the proceeding sheet of the case, it is clear that the defendant number 7 has filed the wakalat on 18/3/2019 and has filed the written statement on 25/7/2019 along with the present IA on 1992 of 2023 to recall the order and permit them to lead the evidence. In view of the above and for the reasons stated above, the IA stands dismissed. Next paragraph. When counsel appearing for the petitioner submits that the order impugned is bereft of reasons, the tribunal has only considered, has in the order, has discussed about the submissions of the bank. Then when it comes to the order, simply has dismissed the IA. It is submitted that the tribunal ought to have looked at the substantial interest of the parties and ought to have allowed the application. It submitted that unless this application is allowed, it would cause a lot of hardship to the petitioner. The Learned Counsel appearing for the bank submits that, as rightly observed by the court, from the year 2019 till 2023, the defendant has not evinced any interest. As such, the court has closed the evidence, and thereafter this application is filed. This is nothing but the delaying tactics, and the petitioner cannot be permitted to lead evidence when he is, and the court had rightly considered all these aspects and dismissed the petition. Next paragraph. Petition. It is submitted that coordinate bench of this court on 10/4/2024 granted it on an order of stay, and from 2020, from the said day, the entire proceedings before the DRT are stalled by virtue of the interim order. Next paragraph. Having heard the counsels on either side, there is a material non-record. There is no dispute about the fact that the defendant number 7 has filed the wakalat on 18/3/2019. Written statement also on 25/7. What is this? I am not able to understand paragraph number 14 of the order.
14 of the order.
14 of the order, my lord.
What does it mean? It says defendant number 7 has filed the wakalat on 18/3/2019. That I understood. And filed the written statement on 25/7/2019. Along with the present IA 1992 of 2023. When is the wakalat written statement filed?
Page number 114 of the 114, my lord. Lord, the case was posted for the dependent evidence on 6/9/2023. 6/9/2023.
So that I understand. When was the written statement filed?
My lord, see, the written statement is filed, my lord, on 25/7/2019.
The written statement is filed on 25/7/2019, and the evidence of the defendant number 7 is closed on 6/9/2023, and the order impugned is passed on on 22nd December 2023. The, no, right from the set date till now, the entire proceedings before the DRT are closed. The court ought to have given a reasonable opportunity by imposing the conditions. And also a perusal of the order discloses that the order is it's not a reasoned order, considering the circumstances of the case and to put a quietus to the litigation, whereby if the defendant is given an opportunity to give evidence, the litigation can be taken to a logical end. In these circumstances, this court is passing the following order. The order dated so-and-so, passed in so-and-so, is set aside, and the matter is set aside, and the IA 1992 of 2023 filed by the petitioner is allowed. Number 2, the petitioner shall, without seeking further adjournment, how much time?
Next date, my lord, 8/6 month.
No, how much time it takes for the evidence?
How much time it takes for the evidence?
The next date is fixed on 8/6 for await orders of the dishonorable court, my lord. On that day, my lord, the defendant.
No. What is the time frame you want me to fix for completing their evidence?
Lord, within 30 days, my lord, yes.
Within?
30 days.
Within 30 days from the date of receipt of the copy of the order, the petitioner shall conclude the evidence. For any reason, if the petitioner fails to adduce the evidence, the court shall pass appropriate orders in accordance with law. Accordingly disposed. This next.
Greatly obliged, ma'am.
9. Say number 9, Ashwin Kumar.
I appear for the petitioner, my lord.
My lords, I pray for some time to file my objections.
My lord, I seek.
It is too early to file your objections. 2024 matter.
My lord, I seek an adjournment for filing of, I'll take a substitute application, my lord. Substitute service for R8 and R9.
You have an interim order?
Yes, my lord.
Yes, you will have an interim order, and the service or notice will not be completed. What is this petition about? Come to that.
This petition is about.
My lordship, sorry to intervene, my lordship. Actually, my lordship, in this case, respondent number 8 is not at all appearing before this honorable court. He is a main culprit in this court, in this case. Actually, he is entered into the tripart agreement as well as this unregistered agreement with me. And that is, it has been respondent number 7.
No, let me look at the prayer. You are for the petitioner?
Yes, I am the petitioner, my lord.
Let us see the prayer that is sought before this court. What is the prayer sought? Look at
my lordship, I am coming, my lordship. Actually, my property is being sold by this respondent number 8, who is a KSR Properties, to the respondent number 9, 10 and 11. And 10 is appeared before this honorable court, and 9 and 11 is respondent number 11 is not accepted the summons also.
You are agreed.
So I may be permitted.
If you are aggrieved by whose action?
Yes, my lordship.
You are aggrieved by the action of which respondent?
R6 and R7.
R6 and R7 is a banker, my lordship.
R6?
R6 is the Axis Bank.
Who
they are
appears for
appeared
Axis
before
Bank?
this court. And R7 is the LIC.
Who appears with the Axis Bank?
Axis Bank is respondent. They are appeared, my lordship. They are appeared.
They already filed the wakalat, my lord.
Wakalat also they
Appear
are
for
filed.
whom?
R7.
R6 who appears?
There's already an advocate, my lord.
That's what, please tell it. Who is that advocate? That's what I want to know.
Advocate with.
Huh?
ಹೆಸರಿದೆಯಾ?
Jay M. Patil for R6. Where is he? This is a writ petition of 2024. The respondents, even till now, have not filed their wakalat. R11, notice to R11 is returned as refused, amounts to deemed service of notice. The petition shall pay the process in respect of R4, 8, 9, and 11 within a period of 1 week, or else a writ petition shall stand dismissed. Only R4, R8, and R9, not R11. R11 it is held sufficient. A week's time, or else the writ petition shall stand dismissed. As far as 6 and 7 are concerned, if the objections are not placed within 1 week from today, they will not be permitted to file.
My lordship. Stay may be extended, my lordship.
Interim order is extended. Yes.
Ashanti Elkanah,
My lords, in this matter, I appeal for the petitioner. Yesterday's matter, my lords. My lords, just have to make one submission with respect to the alternative remedy, my lords, as my lords have observed. My lords,
No.
my lord,
It's not an alternative remedy. It is the remedy available to you, only remedy. It's not an alternative remedy.
no, my lords, I do understand, my lords. I go to your lordship observation. However, my lord, my simple but small short submission is that, my lords, that the alternative remedy or the statutory remedy will be availed if the matter is on the merits, my lords. If the
I think
authority
it's
or the
already
court.
over. You have argued at length. I have considered it. You only
no,
wanted
just
to get instructions.
one ruling, my lords, in fact, the Honorable Supreme Court, where, the Whirlpool Corporation case, my lords,
Where is
voted
it?
in 1998 SCC 1, my lords, where, my lords, if there is a violation of principle of natural justice and there is a lack of jurisdiction.
Where is R3's the postal postal track? You said it is.
We have filed
I
it
just
yesterday,
wanted
my
you to
lords.
place it, nothing else.
We have placed it, my lords. It's placed by a memo, my lords.
See that? Already your order is also ready. They have typed.
My lords, it's the order. In fact, my lords, it's the passed by the Bar Council of India and the State Bar Council. It amounts to civil debt, my lords, and completely debarred me from practice permanently, my lords.
No. It is not item delivered is. Why would it be to him? There should be something if it is. That is a probably a item. No, there should be first column. Address relieved, sent. It is delivered back to the sender. That's not the endorsement. Have you seen that memo? It says delivered back to the sender.
Yes, my lords.
So what is it? What does it mean? You are saying that it is served yesterday.
No, my lords. R3 was served. LR's application was filed pursuant to the order of this honorable court, the coordinated bench of this honorable court. Thereafter, my lords, we paid the process, and the Shara to the court has not returned. However, my lords, I have obtained the copy from the Indian Post Department.
Look at the memo. Look at the copy of the memo if you have.
Please.
Please, my lords. I have, my lords, in the memo, I have mentioned that the postal track report, my lords.
But it says delivered. To whom? What is the memo he says? Let's not go into all that. The memo is filed stating that the notice is served to the respondents, to the LRs of the respondent. None appeared on their behalf. No wakalat is filed on their behalf. It should be at paragraph number I have kept a star here that has to be incorporated in this order. Yes, next.
Grateful, my lords.
Petition number 11.
Petition dismissed. Not dismissed, giving liberty, well, disposed of.
Petition number 11, hearing on
11
IA.
appeared for the last date appearing, Lordship is directed to produce the particulars of details with the mode of payment that we have done. I'm filing that memo to the extent.
Take that.
Page number 3, my lord. The first payment was made on 24/3/2022. An amount of rupees 1,58 lakhs. Thereafter, it continued to make payment 21/2/2023.
So total payment made is 6 crores.
No, bottom 11 crores, 65 lakhs, 43,709.
Where do you get that?
Page number 3, my lord, grand total,
Oh.
bottom, my lord,
Hmm.
11 crores, 65 lakhs, 43,709. The order under page number 13 of the operative portions is to pay 10 crores, 96 lakhs, 38,835, so and so within as and
Send
undertaken.
him a copy of it.
I have given, my lord.
Get instructions from your client.
Please.
The HA has placed before the court the statement to show how and when the amounts are paid to the petitioner,
Yes.
the respondent, and when the counsel for the respondent submits that, he'll get instructions in this regard.
Please.
Petition number 12. Number 12,
I appear for the petitioner.
Kailash.
Respondent, my lord. I filed the objections for the review petition, my lord. Of lapse of 300
No,
days.
only clarification what they are
Please,
seeking
please,
is
my lord, please.
with regard to whether it is from the date of application.
Here it is.
No, but if the petition is filed in the year
16.
for example, 20, you come up with the IA in 2023. So why should it be related back to 2020? It can't be.
Because in another scheme is filed in 2016, same year, my lord. Till now, they have not paid any maintenance.
Forget about it. We are not
Because
concerned with that.
That is
fact.
covered by the judgment of Rajneesh Neha case, my lord.
Huh?
It is covered
What
by
Rajneesh Neha says?
here regarding payment of interim maintenance and payment of maintenance, my lord.
Correct.
Here,
No, it is about interim, from the day application is filed. That is a reckoning date.
no. Here, that case in my learned friend has quoted last hearing, the judgment
No,
of.
forget about that.
Because-
Generally, the procedure is this.
That is,
Whenever you want an interim maintenance, from the date of your application, it will be granted.
it is the duty of the husband from 16. He has not made any arrangement of maintenance, my lord, till now.
So please come to the order.
And,
Come to the order of this court. This is a writ petition.
Yes,
This order is passed in a writ petition.
Yes, and even they have filed another writ petition, my lord. That is
17506.
No. Which order to be reviewed now, for which he is seeking order dated 19/7/2024. This 19/7/2024 is an interim petition. That is an interim order is questioned. Interim order would be from the date you filed an application seeking maintenance, not from the date this is an MC that is sought. In MC is filed in 2020. You wanted in 2023 the maintenance. Why it would relate back to 2020?
No, because MC petition was filed before family court Bangalore, my lord. And it was transferred by this honorable court to Arsikere. She was residing at Arsikere, my lord. And we filed a CMIS petition before Arsikere. He never paid any money. And subsequently, we filed an interim application there. And here this is.
Please come. Let's come to the order at page 12.
Please, ma'am.
Facts are very simple. Issue is very simple. Writ petition is filed, agreed with the order passed in IA number 1 in MC number 27 of 2019. So MC is filed in the year 2019. When is IA filed? Please give the
MC
date
was
of
filed in
filing.
2016, ma'am.
Huh?
2016, ma'am.
What?
MC was filed in 2016.
2016,
16,
2016. It is transferred to the some other court and numbered
yes,
as so and so. So in this 2016 MC, when was the IA filed? Seeking interim maintenance.
Subsequently.
There should be a date for that.
That is 10/1/23, my lord.
10/1/23. Then you are entitled from
Because
that day.
they should pay expenditure of litigation. They are not paid in Bangalore also. They are not paid in Arsikere also.
In order, you should seek for it.
No, my lord, I requested the trial court, and even I have counterclaim in this review petition, my lord. I filed the counterclaim.
Review petition, there won't be a counterclaim.
Because
how can there be a counterclaim?
Because review is
in a
not
review petition?
review is not maintainable because this is covered by.
That's a different aspect. No, you didn't. You are not clarifying it. What is the court asking? You filed an application on 10/1/2023. Court will grant the maintenance from 10/1/2023. When you don't feel the necessity of an interim maintenance from 2016, why should the court grant it from 2016?
Because 16 I filed the maintenance petition, my lord. It was not a necessity, question of necessity, my lord. Already I sought
your
for
maintenance petition and your MC petition have nothing to do with
because this judgment is clear, my lord. Here it covers DV Act, Maintenance Act, and also covers the Hindu Marriage Act, my lord. And it is a discretionary order of the trial court.
According to you,
please, ma'am.
You filed 125 CRPC proceedings.
Yes, madam.
On into year 2015. Yes. So you filed the MC in the year 2016. According to you,
I have not filed. They have filed.
Whoever it is, it will be relayed back to your MC petition.
Yes,
and from that day he should file. Yes, please give that. I am not agreeing with that. Yes, give that order. Take that. Yes, paragraph. Paragraph.
Here the judgment operative portion, point number 3 is very clear.
Page numbers, you have to refer to the page numbers.
Kindly pass over. I have sent for Xerox. Kindly pass. I'm ready to argue, my lord.
No.
Within 1:30 I'll argue.
Page numbers are there in the bottom.
No, I have not got.
Only this has been a citation.
Kindly pass, sir. I'm ready to argue.
No, it's a simple issue. We don't pass over. Where is the way? Which paragraph you're relying at least?
With half an hour, my lord.
Afternoon, I'm not sitting.
Within 1 o'clock, I'll convince.
Call this matter at 1 o'clock. Yes, next.
Serial number 12. I'm trying to pass over. Serial number 13. Serial number 13.
13 is adjourned.
13 adjourned.
That interim order may be extended, my lord. Serial number 13.
Look at it. 13 interim order to be adjourned.
Grateful.
Extended. 14.
For the respondent.
Say for the petitioner, my lord, and the highest bidder, talks are going on with the respondent. 2 weeks time may be done.
Why you are before this court? You are appearing for a borrower.
Not borrower, my lord. The highest bidder in the action during COVID time it took place. I have deposited 87 lakhs, my lord. For balance time was sought and there is some issues in the property also. So 2 weeks time may be accommodated, my lord. We'll see that it is settled and issues could be sorted out.
Which is a asset reconstruction company. The writ petition is filed against so and so, in the light of the law laid down in so and so, in the light of the law laid down in Vishwabharati. Ask them, they'll give so and so. The writ petition against asset reconstruction company is not maintainable. Accordingly disposed of, giving liberty to the petitioner to avail the appropriate remedy. The petitioner shall have the benefit of section 14 of the Litigation Act. Yes, 15.
Bill number 15, K. Chandrasekhar, AGA.
Counsel for petitioner seek for short adjournment. Your senior is
In
not
this
here.
matter, my lord, before trial court, my lord, they made a submission that the honorable apex court has granted stay for the proceedings, my lord. But the order copy is not produced before the trial court nor before the IO, my lord. For that reason, my lord, we are not in a position to proceed further, my lord, in investigation.
Is there a stay before this court?
No, my lord. He made a submission before this court also, my lord.
On before last date of hearing, my lord, not before your lordship, my lord, before last date justice Indrish, my lord. It was submitted by the other side, my lord. Matter is stayed before the honorable apex court.
He said.
It was submitted, not this pleader, my lord. Some other pleader. On behalf of the state, my lord, it was submitted, and matter was adjourned by 4 weeks. It was.
What is this writ petition? Give that.
Prayer is at page 20, my lord.
What is the writ petition about?
Page 20, my lord. Prayer. Appoint any officer not below the rank of assistant commissioner of police, and the state may also be direct not to change the investigation officer during the course of investigation until the completion of inquiry and submitting further charge.
Respondent to appoint any officer not below the rank of assistant commissioner of police in CC number pending on the file the first, and further direct the respondent not to change the investigating officer until completion of inquiry.
This
From
matter, my lord.
2020, it's going on like this.
Yes, my lord.
Actually, I'm a proxy educator.
Charge sheet is filed, my
Short
lord, and
adjournment.
further charge sheet also filed, my lord, in this matter.
Short
It
adjournment.
is submitted with the HCGP that already the charge sheet, further charge sheet is also filed. And the matter is pending before this court from 2022. Let's this matter on Thursday, no further time.
Bill number 16. Bill number 16, Rohan Patari.
Your Leadership, this is a petition by a Japanese national who had secured a favorable opinion recommendation from the State Human Rights Commission on account of illegal detention and custody by respondent number 3. The recommendation was essentially that he was to be paid compensation of 75,000 rupees by the police. Police were to frame guidelines on how inspectors are to deal with foreign nationals, because the reason for this illegal custody was because the concerned arresting officer was unable to communicate with the Japanese national who did not know either Kannada or English as to his rights as an arrestee. And the last was to initiate a disciplinary inquiry against respondent number 3, who was the arresting officer, acting in excess of his jurisdiction, and to recover the compensation.
There is a provision for this, the 25D of the, where, what is that?
20D of the Karnataka Police Act. 20D of the Karnataka Police Act.
There has been a lot of development since then, Your Leadership. I filed this petition in 2022. 30-day time window was given for the.
As far as this prayer of taking action against officers.
Yes, Your Leadership.
Or concern, any action or the overaction on their part, the 20D or so and so will, what is it, 20D? District Police Complaints Authority.
No, that is already commenced. In fact, a departmental inquiry is already ongoing. I'm at a very narrow compass over here, Your Leadership. What has happened since?
He says, taking disciplinary action and recovery of amounts required to be paid by way of compensation.
I'm not aggrieved by the non-taking of that.
That's a relief you're seeking.
I'm seeking a relief. Since the filing of this petition, some developments have taken place. Only 1 second, Your Leadership, I'll take. I filed this petition in 2022 after being aggrieved on the non-action of the police. In 2024, the police writes to me by email saying the higher authorities, administratives on the administrative side of the police force have sanctioned the compensation payable to you. Please share with me your bank account details. I reply to them by email saying, I'm a Japanese national. I have since relocated back to Japan. This is my Japanese bank account. You may have difficulty crediting amounts from an Indian bank account to my Japanese account. Nonetheless, I'm sharing it with you. I'm also sharing with you the account of my lawyer, who is my legal representative. Please pay the compensation to him. This is in 2024. Since 2024, they have corresponded with me at least 4 times saying, we will do it, we will do it, we will do it, but they have not yet done so. Now, Your Leadership, the situation is that in uh, September 20, in December 2024, and thereafter in September 2025, they have issued two fresh communications saying, we have the compensation ready, but we have not got the final go-ahead from our administrative superiors. So till that happens, we cannot do anything. So if the police has already initiated the work of initiating a disciplinary inquiry, if they have already got a sanction for the payment of compensation, they have the details of not only the person to whom it has to be paid in Japan or their advocate, myself in fact, in India, then what is preventing them from carrying out that? That's the only thing I have left.
Yes.
As far as the initiation of disciplinary action is concerned, my record shows that, my lord, the show cause notice is issued to the relevant officer at respond number 3, and action said to have been taken are under consideration. In respect of payment of compensation.
It's under consideration.
My lord.
Right from 2022, disciplinary action is under
No,
consideration.
thereafter, not 2022, my lord, it's on maybe 20.
I'll grant 2 weeks
Weeks.
time.
Yes, madam.
2 weeks time to you. Within 2 weeks, I want objections on record with regard to the disciplinary action.
Yes, my lord, I'll
And,
place.
with regard to the compensation that is going to be paid to him. And what is the compensation?
75,000.
75,000.
In fact, I'm happy for it to be.
For not paying that amount,
My lord, it has listed first time before your lordship.
the land council appearing.
I'll
to
take
the
instruction and
petitions
make
of-
submission to that extent. I'll take instruction and make submission. If
The
it is
land
ready, then
council-
we'll disperse it.
Council for the petitioner submits that. Right from 2024 or 2. This
24.
Communication.
Communications from 24.
Right from 2022, the petitioner has a communication from the respondent that the compensation of an amount of rupees 75,000 is awarded to the petitioner. As a petitioner is a Japanese national, and it is difficult to transfer the amount to his account. He has sent emails to the respondents that the same may be deposited in the account of the advocate who is representing him. It is a submission that right from 2022 till now, nothing has happened. It is also communicated that disciplinary action has been initiated. And what is the outcome of the said disciplinary inquiry is also not forthcoming. Leonard AGA submits that he would get instructions in this regard. Next paragraph. When they have awarded the compensation to the petitioner,
No, when the state is not awarded, it's the national, no, state commission, human commission has ordered to
when
pay.
whoever it is,
Yes.
what is
Based
that?
on that-
State Human Rights Commission.
State
State
Human
Human
Rights.
Rights Commission. When the compensation is awarded to the petitioner, why the same is not paid? And what is the outcome of the disciplinary inquiry initiated against the concern? A detailed affidavit shall be filed, the objections shall be filed before this court by 23rd of April. This is matter on 27. If by that time the objections are not placed before the court, the concern shall appear before the court.
I'm obliged.
19 and 18 adjourned. Cell number 19, Anusha Nandish, Kumar Jain for respondent.
Give the better.
Third respondent, I have filed the IA for vacating.
Yes.
Lord, in this matter, my lord, I intend to file certain other documents on record.
No, let's see. what
The issue is this.
What is the relief? Demand notice dated under section 13(2). Have you replied to the
Initiation.
demand notice?
Yes, my lord.
Relief sought is, my
Initiation
lord.
of
How can you
proceedings.
question a 13(2) notice?
The PC Act is not applicable. That's what the relief, main relief in the writ petition against the third respondent. This is, so are the society, third respondent.
But it is
applicable.
It is
The issue,
applicable.
now the issue is settled. The other issue is that, my lord, they have already initiated prior to issuance of these demand notices. They have initiated proceedings under the Savarda Act. Attached this very same property under those proceedings, my lord, that attachment remains.
No, you have questioned only 13(2) notice.
Please.
Tell them that the 13(2) notice is bad for what reasons? If you tell them, they're bound to give a reply under the act, under
Please.
13(3)(a).
Please.
And why is this writ petition filed? And why is it pending before this?
Lord, I have already given my representation in reply to these notices.
Whatever, let them act upon that and take further steps. If you are aggrieved, you can come,
Yes,
not
With that-
before the court, go to the DRT.
with that finding, get.
That present writ petition is fine.
Coordinate bench recently dismissed identical writ petition wherein I am the respondent.
The present writ petition is filed seeking the following prayer. Land council has raised several grounds, but the fact remains is that the writ petition is filed questioning a demand notice dated 13/2. When a demand notice under 13/2 is issued, the petitioner is legally obligated to issue a reply, and the respondent bank has to give a reply to the same. Without any of that procedure, the petitioner ought not to have come before this court by filing an application for questioning the notice dated 13/2. It is a submission that the petitioner has given his reply to the 13/2. If not, the petitioner within 10 days from today, for 10 days from the date of receipt of the copy of the order, shall give his reply, and the respondent, in accordance with the Surface Act, shall proceed accordingly. If the petitioner is aggrieved by any of the subsequent action taken by the bank, is always at liberty to avail the appropriate remedy before the DRT. Accordingly, the writ petition is disposed of.
One submission, if at all he refers the representation in this writ petition, if at all produced, it is very easy for us to reply.
No, I said within 10 days you should give you now.
I will make a fresh representation with a comprehensive one.
Yes, next.
Lord, the interim order may kindly be the
The
interim protection.
the interim order shall be in effect for a period of till the bank considers the 13/2 demand notice, the 13/2 reply.
If at all he has issued, he will.
No.
Might have been replied
He'll be
also.
giving it within 10 days from the date of receipt of the copy. Till you give your reply to that, he'll have the benefit of the interim order. The interim order already granted, petitioner shall have the benefit till the bank replies to his reply. Yes.
Writ petition disposed.
Response to his reply under 13/2.
Lord, within 10 days from the release of the order, my lord. Within 10 days, I will make a representation within 10 days from the release of the order.
I said so.
Please.
Yes.
Number 20, yes, Rashid, T.P. Mukherjee.
I appear for petitioners, my lords. It's a case where, my lords, the petitioners are neither the borrowers nor the guarantors. They are, my lords, the purchasers of the apartments and, my lords, commercial buildings. In the last date of hearing, my lords.
Yes, I remember.
Yes, my lords, on the last date of hearing, I took adjournment on the pretext that, my lords, the bank contended that, my lords, it is a project loan. But, my lords, they have sanctioned the loan insofar as, my lords, other apartments may be permitted to produce these documents, my lords, along with the memo. Which clearly shows, my lords, bank is also aware of the fact that, my lords, residents are occupying. They cannot contend that, my lords, we are all unauthorized occupants. My lords, now the bank is colluding with the, my lords, borrowers, and they want to oust me from the property. Though I had offered, my lords, I am ready to purchase the property.
If that is the case.
My lord, that's not there now. Now,
Take
no,
that.
one case.
Have
has given a mention.
you given him a, look at it
One
before
case.
responding.
Now when I look up, my lord.
If you respond before looking at the document, then it's a problem after that.
Oh, my lord, because last.
Look at the document, I will hear you.
Vasudev Prabhu, this case, my lord, he filed on the commercial appeal. There is a stay. So long Vasudev Prabhu, bank is not touching at all. Vasudev Prabhu is having two
It's not
loans.
about bank touching the property. It is about when you have given a project loan. You say you have given a project loan and all those apartments are, and for the apartments in that, you have again, you will give you give a loan for the purchase of that.
But he has purchased this property from that builder, that owner of the person who has constructed.
Loan who has
building.
given?
Respondent number 2.
Loan.
Respondent 2, that he approached the bank for the loan for purchasing the flat.
Oh, your
My lord,
submission on the
my
last
lord, this
question was not this.
Project loan, how it happens, my lord. Project loan is given for construction of the building. And any person who is interested to buy the flat, he can approach the bank also. Project loan is something is different. His loan, housing loan is something is different.
Okay.
Housing loan and project loan, how you can mix? No. But what, my lord, this is what happened, my lord. Here in this case, my lord, these 13 persons, 13 or 14 persons out of so many persons.
No, 1 minute. No, you have given the project loan.
Yes, my lord.
The builder or the developer has sold the property to A. For A, you have given the loan. Then in case of default, either from the builder, or if there is a default on behalf of the builder or the developer, what will you do with regard to this A's property?
This person, this was the, but you are
Not
not
that
touching
person,
it.
I'm just saying A's property.
No, my lord, that is, no, my lord, now your lordship is telling now here in this case, project loan was given. And all these persons, my lord, this very surprisingly, unregistered agreement is there. On that basis, they say that you have given the loan. But as on date, entire property is standing in his name of the owner. And that bank has issued a notice for the project loan. Now, this loan, my lord, he has to, now that.
No, for this person, it is standing in his individual name.
That is his name, that he is not there, bank has not issued notice to him at all. Because this was the, but that's separate, I have mentioned in my objection also, this case is different. He has nothing to do with this. Now, other persons and all who has occupied this, that unauthorized occupied, saying that we are in possession and all, but how they can get the question? Now, 17 my agreed person, who is whether now these persons petitioners whether agreed or not. Now, as is rightly, they are not mortgager, they are not borrowers, they are not the owner of the property. Just by merely sitting in the flat that occupying, stating that you have got the right thing. And how this they can form an association? For that also there is a rule. Simple that's a farm 13% farm association is no.
Where are your documents?
My lords, I have produced those documents, my lords.
Agreement of sale.
My lords, on the basis of
And
agreement
your
of sale.
prayer, my kindly see, my lords. Prayer is very interesting. They say that the bank should not take possession of the realize the property till they are proposed to file a case under this for possession. When that is decided, we will see. When it will be decided, bank, my lord, we have given the note. There is 7.5 crores. That amount has been recovered.
That is why, my lords,
now mortgage of property is the name of the borrower.
No.
And now
there is no legal right.
My lords,
Where is the
I'll
legal
point out,
right?
my
That
lords,
is what I am
my-
telling you, my
one
lord.
second, biಡ್ತೀರಾ submission ಮಾಡಕ್ಕೆ?
Court is asking
My lords,
me, what is
no,
the
no,
legal
court
right?
is asking me. Now, my lords, may kindly appreciate two things here. My lords, so the petitioners and other occupants of the my lords apartments are before either commercial court or before civil court or before my lords consumer court. There are certain orders passed by.
But they cannot be before any of the courts because you have no document in your
My lords,
favor.
so now on the basis of the agreement of sale, my lords, what happened, my lords, here?
At best, you will have a right for subsequent performance,
My lords,
not anything
I'll
else.
point out, my lords. My lords, sir, this project was, my lords, this particular respondent number 2 availed loan from the bank. My lords, so on the pretext that, my lords, he will clear the loan, he enters into an agreement of sale, my lords, when these properties were brought for auction on an earlier part of time. My lords, we have paid the amount, we have, my lords, we are put in possession of these properties, apartments, and we are staying there. There is no dispute regarding that. On the other day, my lords, I have pointed out from the
No, but
order.
right in an immovable property will be transferred by way of a registered
My lords,
document.
I'll come to that. Now, since respondent number 2, my lords, kindly see the conduct of respondent number 2. He goes and writes a letter to the SP of Udupi and also to the Bescom department to disconnect the electricity, disconnect the water, and he writes a letter to the bank saying that, my lords, they are all unauthorized documents. You take action as per your
So why
this
have
thing.
you not initiated any proceedings?
We
against
have
him?
initiated him against
What
him.
happened in that?
Now, those proceedings are pending. In the meantime, my lords,
So have an interim order
my lords, in some of the matters, we have the interim order. I have pointed.
to enjoy with that order.
That is why, my lords, I now kindly look at our fate, my lords. Now, the respondent
No,
number.
but your fight is you have invited it, without a document.
Now, my lords,
Why did you pay the money
Now-
without a document?
please, my lords, now kindly look at this, the fact, the conduct of respondent number 2. My lords, he goes and says, my lords, these apartments, kindly see annexure A also for a moment. Selective, my lords, of auction. They are not bringing all the properties for auction, only selective apartments. Why so? I pointed out 9 flats are there, 2 commercial premises, 1 commercial premises is there. I'm ready to buy. What is your outstanding? We will clear it as an association. We don't want to get out of the building because our hard-earned money is
It
there.
can't be an association for that.
My lords, now that is registered also, my lords. I can place it on record also. The authorities, just because, my lords,
People without a legal right.
my lords, my
Either they are
rights,
the residents of the apartment.
my rights are to be decided by the competent civil court.
Unless and
Now,
until your rights
imagine
are
a-
crystallized.
Now, imagine a situation where, my lords, if we are outstead by virtue of this sale, what about the pending proceedings? I am fighting against him.
Get injunction.
That
from
is
the
why, my
competent
lords,
court.
we have the injunction order. Division bench of this honorable court granted injunction order insofar as one aspect. My lords, may kindly appreciate, my lords, on the last date of hearing, my learned friend submitted that, my lords, it is a project loan. And my lords, other apartment owners, we have brought all the apartments for auction. My lords, to point out.
No, it is like this. You have no legal ground before the court. Only thing last time I asked was, if it is convenient to the bank, we would do it.
That is
Because
what
you-
precisely we
but
requested.
because you have no legal right.
Milords, that is what we are precisely requesting with the bank. We are ready to
If
clear
they
it.
are accepting, it's fine. If
Milords,
they're
they are not
accepting,
even
the
ready to
court-
go to mediation also. I
court
requested them.
cannot- The court cannot compel them, and they have also their restrictions. How can the bank accept?
Milords,
You don't have a
ultimately,
document in
ultimately
your
bank is
favor.
worried about their money. And ultimately, I will be fighting with Milords respondent number 2.
Unless and until respondent number 2 accepts.
Milords,
And he's the owner.
I said, Milords, I said, I am ready to buy these apartments. You please give us.
Why will, no, the problem is with you and with your vendor. You have to settle it out with him.
He is not coming forward. He is colluding with the bank.
Because he's not coming, you can't sue the bank.
No, bank is also sailing with the Milords.
They will,
The reason is,
record the
no,
money.
bank is not worried about Milords bringing the property of Milords to the second respondent.
But your client needs to be diligent. He can't give the money on an agreement of sale and keep quiet and enjoy the
No,
property.
we have not kept quiet. That is why I have produced.
Why did you pay the money without a registered sale deed?
Milords, what happened, Milords, sir? He said, Milords, immediate threat was there. Milords are well aware, Milords. When the projects are coming, Milords, he has entered into an agreement of sale.
Nobody in the present world without legal advice do nothing. If they have done, they're doing it at their risk, and it is courts will not come to the rescue of
now-
persons who are not diligent.
Now, Milords, the bank is Milords playing Milords dual stand here.
They're
Now,
doing their work.
No, Milords. On one hand, they say, Milords, it is a project loan. On the other hand, they have sanctioned loan for 9 other apartments. Now, if
They
it
have
is,
a registered sale deed, they have a right.
Milords, now it is not so, Milords. Kindly see, they have not produced the registered sale deeds. They are also on the basis of agreements. 9 apartments are also on the basis of agreement.
My lord, the bank issued the question notice. Then borrower came to they filed the essay before the DRT.
Basing on an agreement of
essay
sale
was-
also, you will grant loan.
But my lord.
Basing on agreement of sale, you will grant loan.
No, we will not grant loan that. Now that is why your lordship say 100 cases are there. That is because of that. One case, that case you are posted.
tripartite
That is different.
agreements.
These cases, and my lord, for just 1 minute, my lord, that is similar case I take. There was a case in 2019, Andhra Bank. Like that, so many persons he has not issued a seal date. Then all the apartment owners, the big farmer association, they approached the same Andhra Bank. Please give me 2 crores. We want complete and we will occupy. Then we will pay the money. And the Andhra Bank took a decision. They gave the money. All these persons completed work. They occupied. Everything was over. So that is all different. But here, my lord, here first of all, to come before the honorable court, they should have a right. Now, then the question was taken by a bank. In the question was, you filed the petition. The petition also dismissed.
No, the sale of the property, for example, you fix the price at 1 crore. 1 crore, they're ready to pay, ready to buy the property. You have to sell the property, isn't it? Now, because the borrower has failed to pay the amount, you will sell it either to the petitioners or anybody. What you want is money.
That is why we issued sale notice. This honorable court said, please defer the sale for some time. Sale notice is already there. Now all these people can participate and take the property. Sale notice is already there, my lord. This honorable court has passed an interim order to defer the sale. That's the interim order here.
No, if he places before the court that basing on an agreement of sale, your bank has granted the loan.
With the
proof. That's what's the but only. That's the difference. That is what I will explain, my lord. Except that no bank has not granted any loan to anybody.
Is it an agreement of sale?
No, this is different, my lord. That one.
I may be permitted to point out, my lords. Kindly see the very same memo. Go to page 5, my lords. It is not only in respect of Vasudev Prabhu, in respect of others
This is
also.
Canara Bank.
Same bank.
If it is Canara Bank, it might have done.
My lords, kindly go to page 5.
No, this is different.
One second. I'll point out.
That's what he's doing, Canara Bank.
Kindly.
The other day, in other case, I have ordered notice to the Reserve Bank of India. But I'm
yeah.
going to come down heavily on this. This is the manner in which, what do they think? Does the bank think that they can, on their whims and fancies, there is no rule, there is no rhyme, there are no circulars by the Reserve Bank? Whatever you want to do, you're doing. When you don't want to do, you will remember Surface Act and rules. When you want to do it on your own, then no rule, nothing. Will anybody grant a loan on agreement of sale? What is his right?
Kindly go to page 5, my lords.
And when sometimes you have to think about equitably, which is not, it's also beneficial to the bank, then you remember all the rules.
Kindly go to page 5, my lords.
Yes.
Kindly see, my lords, the name of the persons. On the top, Girish Shaital and Sujata. One second.
No, regarding the Vasudeva Bhatt, my lord.
No, Vasudeva Bhatt alla idu. Second one, I'll point out, from 9 apartments, I'll point out. Kindly see nature of the limits, name of the borrowers, Girish Shaital and Sujata Shaital. Purpose may kindly be seen, my lords, on the top. Purpose. Purpose. My lords, page 5 only, my lords. Third column, my lords. Purpose. To sanction a housing loan of rupees so and so for the purchase of under construction residential flat, number so and so. Now kindly go to page number 6, my lords. Kindly go to page 6.
Please come. The bank, counsel appearing to the bank submits, sir, in respect of some of the flats, basing on an agreement of sale, the bank has granted loan and they are not taking action. When it comes to the petitioners, no doubt, though the petitioners are on a agreement of sale, the approach of the bank is different. The respondent, Canara Bank, shall file an objections, shall file the concerned shall file an affidavit before this court. What is whether specifically stating whether they have granted loan on basing on an agreement of sale in respect of this building. If at all granted, what are the for how many people the loans are granted? This affidavit shall be on record by 21st of April.
Interim order.
Interim order earlier granted is extended.
Great.
Sale number 21. Sale number 21.
I pay for the petitioner minutes. Affidavit has.
Petty.
Call him.
I'll call.
Yes, next.
Sale number 22. Krishnamurthy KR.
For the respondent matter.
Yes.
This is a
Why is it adjourned on the last occasion?
Areca matter. They said that clarification was provided by the state.
Saying that it is a notified
agriculture.
product.
It is there in the Schedule 8 of the APMC Act. Lordship permits, I just want to rely the division bench judgment of our own High Court relating to the APMC Act, Schedule 8, Lordship permits.
That you have already relied on, if I remember.
Yes, because there was a copy also there at some article, and also in the same schedule, the article number 1 is an Areca net. So the division bench in the what we produced for the deciding the coffee plantation, it was been considered state enactments for arriving that what and all the plantations had been exempted, because section 31I of the Surface Act specifically says that agricultural land Surface Act should not be initiated. Their claim is we have grown the Areca nut plantation and Areca nut plantation should be exempted, and we told that Areca nut plantation and also the coffee plantation, they are the plantations. They stand in the same line. And
what is the analogy for that?
So for that, if Lordship permits, I would like to place the division bench judgment of our own High Court Lordship. It was relied based on the Apex Court decision.
Take that.
The paragraph number 22. The last page. My lord, this was a case where the dam was supposed to be constructed, and there was Areca nut plantation, coffee plantation, rubber plantation, and the Iberian line. And the award has to be passed based on whether they stand on the same footing in the income perspective or whether it's a plantation. That was been decided at the paragraph number 22. Lordship permits second number 2. That Areca nut is a plantation crop. That was the decision. And that there is no appreciable difference between the economics of the tea, coffee, and rubber plantations. And the Areca plantation is beyond dispute in any of the pronouncement of the Honorable Apex Court and so and so. My lord, this is the case where some exemption in the
Where
Kerala.
is this judgment?
The Apex Court judgment.
You have a copy of it?
Yes, yes, Lordship. I have a copy of that. Lordship permits.
Take that.
The reason for that, Lordship.
Paragraph number?
The second page, Lordship. Second page, the left side, the point number D, Constitution of India, Article 14. Lordship, in this particular in this particular article, there was an exemption had been given for the plantation lordship. In those plantation, the areca was not been included. And the land grower of the areca challenged before the Honorable Apex Court, this particular thing violates the Article 14. The Honorable Supreme Court had clearly held, considering everything, the areca nut is a plantation. Same was definition was been referred by the division bench of Oran High Court. Yes, lordship. And areca nut is a plantation.
Read.
The provisions relating to the plantation, insofar as they do not apply for the
paragraph?
pepper and the areca nut plantations.
Paragraph.
So, my lord, the second page, the point number D, left side. The validity that was being challenged, lordship, the provisions of the particular act before the case. Am I permitted to read that one?
Areca and pepper plantation. How it
Have
starts?
not been included because there was a definition was been given who are all the areca nut plantation, and these two articles had been excluded. And because of being agreed, the areca and pepper plantation have not been included in the definition, section 2 and subsection 39 of the act. There is, however, there is no appreciable difference between the economics of tea, coffee, and the rubber plantation and the areca and pepper plantations. Considering the object and purpose of the act, the basis on which the exemption had been granted in Article Chapter 2 and 3, the plantation is defined. There appears to be there is no reason for making any distinction between the coffee, tea, rubber, and on the one hand, the areca nut on the other. And the provision relating to the plantations are violates the Article 14 of the Constitution. This is the judgment, lordship. Based on the division bench is held that areca nut is a plantation, and there is no difference, economically difference between the plantation, other plantation crops, especially the coffee that we have taken the specific contingent. The division bench, the other division bench very clearly differentiates. And also, my lord, this APMC Act been considered in the another judgment because, my lord, the areca nut is called as areca nut in the coastal region of the Karnataka. The same commodity has been called in the different names in the different parts of our own country. Somebody is called as supari, somebody calls it as betel nut. That is a provision. That is the reason I just want to place before this honorable division bench. The same commodity had been considered. Paragraph number 29. My lord, page number 23. This is the cost title is run because multiple petition had been clubbed together. That is the reason, lord. Page number 23. 23 is the first thing. So the questions had been framed. The 3 questions had been framed. The question number 1. What is the purpose of this APMC Act? And the Schedule 8 is specifically relied on the next page, my lord. 24. All article had been excluded. The areca nut stands in the first number and the coffee stands in the 11th number. My lord, this has been in the first paragraph itself. The division bench clarifies that as per section 2(1) of the asset, agriculture produce means the produce or the goods specified in the Schedule 8. And the Schedule 8 deals with the plantation and space. These are the plantation crops. And my lord, if lordship can able to see the next page, page number 25, the first thing, the commodity called supari. The question is whether supari, betel, and areca nuts is the same or the different. Division bench gives the conclusion that different part of India, the same commodity will called in a different name. That is the reason which commodity is not declared, because the supari they are claiming that it is not declared in the schedule. So that is the reason it's not applicable. The honorable division bench further clarify that the commodity which is not declared as a notified under agriculture produce in the act, and it is not included in the schedule annexed to the statute. Therefore, they have contended that agriculture producing market cannot interfere with their trade and supply. My lord, now, page number 29 may kindly be seen. My lord, sorry, I may be permitted to take page number 26, the next page, lordship. Now, what is the purpose of this APMC Act? Because, my lord, there is a definition called agriculture produce.
What we do is we'll complete reading the whatever paragraphs you are relying on in this judgment, then you can make submission.
Yes, lordship. My lord, page number 26. Thus, it is crystal clear that word supari is nothing but areca in English. And the next, in the same continuation, paragraph number 6 of the Constitution bench had been extracted in the same page, lordship. The marketing legislation, especially the APMC Act, is now a well settled feature of all commercial countries. The object of such legislation is to protect the producer of commercial crops from being exploited by the middlemen and profiteers, and to enable them to secure the fair in return for their produce. My lord, this is the particular purpose had been served. With this, my lord, page number 29 may kindly be seen. The first paragraph. That is the last conclusion of the question number 1 by the division bench. There is no difference between areca and supari, and it cannot be said that areca and supari are two different products. As stated earlier, areca is referred as a supari in North India, and in South India it is referred as a areca. Therefore, we are of considered view that areca nut and supari constitute the same commodity and not the two different and independent commodity. Hence, we answer the question number 1 in the affirmative. My lord, page number 2, because there are two different judgments have been clubbed in the last from that one only. The page number starts after 1 and 2. After 30th, it starts at page number 1 and 2, the same judgment. After 29, they start with the page number 1.
No.
My lord, after
29.
29, the same judgment they numbered as, because I downloaded it from the our own website.
No, in this copy, it is not like that.
In continuation,
It's Kumar, yes. After that,
after that they made as a number.
That is at page number 39.
Yes, my lord, page number 2, the last paragraph. The learned advocate general assisted the court as amicus curiae that he is referred a certain articles by the reputed authors on the history of arecas. All these authorities indicate that what is areca in Kannada is known as supari in North India and also referred to by the other names in different parts of the India. My lord, the page number 5, the last paragraph. Areca is a slender stemmed palm and is native of Malaya. It is cultivated primarily for the kernel obtained from the fruit. It is a common masticatory nut, popularly known as areca nut, betel nut, or the supari. Next, in the same line, paragraph, my lord, page number 6, last paragraph. The commercial cultivation of areca nut is done only in India, Bangladesh, and Sri Lanka. However, it is grown as a stary crop in Indonesia, Malaysia, Burma, and some specific ocean islands. India occupies the first place in respect of the areca under areca plant production. India produces nearly 90% of the world production. My lord, the humble submission is from the division bench. It is very clear that the same commodity had been named at the different parts, including the betel, areca, and supari. And it's also been the division bench clearly mentioned that APM Act Schedule 8 is an agriculture produce. In that agriculture produce, the coffee plantation also there, and also the areca nut is also. And another division bench clearly says that areca is the plantation, and economic wise there is no difference between them, relying upon the Honorable Apex Court detail. And with that, my lord, if lordship can able to look into the Umesh Rao's judgment, Ramesh Rao's judgment, lordship, while deciding, lordship is having the Ramesh Rao's judgment, Honorable Justice B.V. Nagaratna, on the coffee plantation, lordship.
Ramesh Rao.
Ramesh Rao. Page number 92.
Page number?
Page number 92. Paragraph number 59. Because
let's read.
Yeah. Expression, paragraph number 59. I may permit to read from the bottom. The expression plantation crop. We have perused the definition of the word agriculture under various enactments. That means the various state enactments have been considered. Under the Land Reforms Act, and definition of the agriculture is an inclusive of one which includes the raising of the crops, grass, and the garden produce.
No, internal page. What is internal page number?
Internal page number 92, lordship.
1 minute.
92, paragraph number 59.
1 minute. We have perused the definition of the word.
Yes, expression plantation crop is defined to mean cardamom, coffee, pepper, rubber, tea, and etc. My lord, the contention of the petition is that the areca nut was not being shown in this. But already the settled position of the division bench of this honorable court saying relying upon Supreme Court, the plantation is the plantation crop, and there is no difference economically between the coffee and what already been settled. Now, Lordship, the Lordship can able to see the next page, because by relying upon the page number 94, by relying upon state enactment, the division bench had laid on some of the tests has to be passed, because some of the tests had almost 7 tests had been defined to give an exemption under Surface Act to Agricultural Act. In this, test number 3 is very important. Page number 94, test number 3. Generally speaking, while determining the nature of the land and as to whether it is agricultural land, the character of the land according to the purpose for which it is meant or set apart can be an important test. Thus, there must be a connection between the user of the land and the purpose, which is agricultural purpose. Also, agricultural activity does not mean only cultivation per se, but it is an integrated activity, which would include not only the cultivation of the crops, but also its process for its future use. My lord, I may be permitted to pause at this moment. If it is a rice, paddy or coconut, what is the future use? So we are well known. It is an essential commodity so that human cannot be able to survive. But it is an aracanut. It is a cash crops, and also I can able to show from this statement only, the division bench clearly held that betel is an article of luxury. It is not an essential commodity. I may be permitted to bring the lordship to the page number 59 of this judgment, because this observation is done after discussing at page number 57. Page number 57, lordship. The term agriculture has been in the wider sense as comprising within the scope as the basis as well as the subsequent operation described above. The product may be fruit grain or vegetables or fruits which are necessary for the subsistence of human being, including the plantation, growers, grass or pasture for the consumption of the beast and or article of luxury such as betel. My lord, why I referred the division bench previously is there was a different name for the same commodity. So I just have to, whatever the betel, this particular thing is there, my lord. It is the form of betel and the betel nut. And the honorable division luxury such as betel, coffee, tea, tobacco, etc. Commercial crops like cotton, flax.
Page 56, I don't find this.
My lord, 57, the first paragraph.
It starts with?
Term agriculture. Term agriculture, the last 3 lines, lordship. The products may be fruit grain or vegetables
or fruits
which are necessary for subsistence of human beings, including plantations and growers, or grass or pasture for the consumption of the beast, or articles of luxury such as betel, coffee, tea, spices, tobacco, etc. My lord, that is the reason I relied upon the previously to say that areca nut is the betel nut, it will be called in the other part. That is being considered by the division. And the division bench in this matter also held that this particular commodity, in the different name, they says that areca nut, in the form of an areca nut, it is not been mentioned. But in the another form, where the division bench says all are the same name, same commodity, different names. This is the article of luxury. Whether this, what is the future use? If it is a subsistence of the human being, yes, that has to be exempted. It is not. It is a choice. It is an article. That is the reason, my lord. At the test number 3, it won't pass. That it is stands similar with the coffee and the other plantation, where the division bench I just relied. My lord, the test number 7 may kindly be seen. Page number 95. The last test had been defined by the division bench to give an exemption.
Page number?
Page number 95, test number 7. Right inside last. Number 7. 95, lordship, sorry, I may be 95, last test, page number, test number 7. It says, in the event there is any change in the user of the agricultural land for non-agricultural activity, the same would also be a bearing with an action of initiated under the provision of the Surface Act. My lord, as per their claim, at the time of mortgage, it is a areca nut plantation. That, and it is areca nut plantation doesn't come under surface, so we have to be exempted. The sale notice issued is null and void. Our statement of objection may kindly be seen where we produce the photographs. If the photographs, they can able to mention that it is Arakanat. They combined with the coffee. More than 50% of the land is acquired with the coffee. There is an existence of Araka. We won't dispute. They more than 50% of the land is covered with the pepper. They still claim that it is Arakanat land. Our statement of objection you have produced and they also produced. Same may kindly be taken into consideration because this particular test in the event there is a change in the user of agricultural land. This division bench is clearly that coffee doesn't come then. Evacuate that. Arakanut plantation they have, but they have taken the benefit. But if the division bench judgment is considered, economically there is no difference. So both stands in the similar. That is the thing, my lord. Even though they claim that its entire thing is Arakanut plantation, we won't grow the coffee. But the situation shows that something different. There is a non-agricultural activity. So they don't require an exemption. That will be our humble submission. And we have produced the photograph. They also produce the photograph. One or two photographs, there is a deviation. That will be our humble submission.
There is a difference insofar as these photographs are concerned. At
No,
my
let's not
cost,
go to the photo, we'll go to the photographs later.
Yes.
What do you say about the judgment?
insofar as this one is concerned, of course,
No,
today.
basing on what? You say that areca nut is an agriculture produce.
Yeah.
But it is not a non-agriculture produce.
It is now security interest is created in respect of the land. If we see the document, security interest document between the parties, which is the crux of the whole thing. In the document, it is shown as the land is securitized.
No, but ultimately the subsequent.
I will come to that point, my lord. I understood your lordship's
It's not
question.
about
I understood.
notified
I'll
as
come to.
agriculture land, but what is the usage of the land?
I will come to that, my lord. So now interest is created, security interest is created in respect of an agricultural land. Now areca nut is grown. Now argument is being canvassed stating that areca nut is a plantation crop or commercial crop. It is not a.
Example, if it's a coffee estate.
Yes.
Or coffee is grown.
Yeah.
If the property is registered as an agricultural land.
Yes.
Then in that case, the security interest is created in respect of the
That is
land.
exactly the division bench has interpreted.
Then in that case, according to you,
Yeah.
it is whatever is a commercial nature of the activity, but it is an agriculture.
That's why it is a division bench, where division bench has analyzed the whole thing after looking at all the Supreme Court decision and other decision and the statutes placed before the division bench. The division bench has specifically stated in the paragraph that we have to go by, because this land is coming under state list, not under the central list. Agriculture land is coming under the state list, not under the central list. This enactment is a central enactment. So therefore, only one sentence is made that this act is not applicable insofar as the agriculture land is concerned. The division bench has not deviated from its consideration insofar as whether a land is in making the contextual interpretation. Though it is an agriculture land, for what purpose it is used, whether it is for a commercial purpose or for a agriculture purpose. While looking at that, the court has considered, this honorable court has considered, this land, see, all lands are agriculture land unless it is diverted from the agriculture under the Land Revenue Act. All lands are agriculture land. Now, under the agriculture land, now coffee is grown. It is also coming under agriculture land. There is no dispute about that. But under the agrarian reforms, land reforms.
Coffee is held to be a commercial crop.
Commercial crop, because under the Agrarian Reform State Act, Land Reforms Act, this only about 4 or 5 are considered as the plantation crops, whereas areca nut, cardamom, or coconut is not included in that. Not included in that. The division bench has gone on that basis to say that the coffee is a commercial crop or not. And it also considered 3 important sections of the Land Reforms Act, where section 17A, 17MB, where there is a bar for non-agriculture to purchase an agriculture land. That is not applicable to the plantation which is defined under the Act. The plantation is defined. Plantation crop is defined under the Act. And insofar as those act concerned, the state itself has made a specific observation that this restriction for purchase of agricultural land is not applicable to these plantation, this one, but areca nut is excluded from that. And coconut is excluded from that. Anybody can purchase coconut garden or areca nut garden.
The criteria for that is altogether different.
Beg your
Not
pardon.
that criteria
Yes.
for declassifying the two is altogether different.
No, in this judgment, Your Lordship, may
No,
kindly-
that might be,
Ah.
but when you.
So
for the
therefore, when considering the
purpose-
coffee,
One minute, for the purpose of under the Surface Act,
yes,
whether a particular operation is an agriculture or non-agriculture operation,
Yes.
the criteria is altogether different. Forgetting about the conversion of lands, alienation of lands,
Yes.
sale of lands,
yeah.
all stand on a different footing. Why
Kindly
the
see
whole
para
purpose
46
is,
of the
it is
judgment.
not only the purpose that
Yes.
agriculture comes under the state list, enactment is a central enactment, that itself not is the one.
Therefore-
But the whole thing is
Yes.
to protect the farmers and other people from that,
True,
who are conducting the agriculture operations.
True. True, madam. Now, insofar as the interpretation is concerned,
When
we are
you're
all now
doing a
bound by the
commercial
division bench.
activity, when you're doing
Now,
a
Your-
commercial
Your
activity,
Lordship, may kindly see, insofar as the.
why should you be protected is a question.
No, insofar as the interpretation is concerned, contextual interpretation of section 31, where it says is concerned. Now we are all bound by the division bench judgment. Interpretation is concerned. If any question arises tomorrow, a particular crop is commercial or not, the
It is not an exhaustive discussion on everything.
kindly see
It is
46.
that
That's why-
discussion
that's
of the,
why- that's
no,
why-
the discussion of the division bench is
Yes.
pertaining to the issue involved,
True, madam.
and whatever or the.
It has not
connected issue-
curtailed the Your Lordship power to consider otherwise. That's true. But kindly see in a broader aspect, kindly see page 40, para 45 and 46 of the judgment. Because that is regarding interpretation only. I am actually reading SCC, my lord. Your Lordship is also looking at SCC.
Oh, this is.
No, I have filed actually. I'll just pass on because that will put us on the same page, madam. Madam. Yeah, copy.
Yes. Paragraph no. which page?
45, my lord.
45, page number?
Page 31.
Yes, I got it.
Yes.
It's 45.
Thus, the question in this case is whether the coffee plantation could be interpreted to be agriculture land within the meaning of section 31I of Surface Act, in which case it is a bar for the applicability of the provisions of the Act. In our view, in order to examine a challenge to an action initiated under the provisions of the Surface Act in respect of an agriculture land, and as to whether the subject land is an agriculture land or not, the petitions filed under Article 226 of the Constitution of India were maintainable. In such a case, the High Court cannot adopt a pedantic approach, but has asked to decide the matter, keeping in view of the fact that the right to property continues so and so. Then paragraph 46. Therefore, in our view, the writ petition raised a question about the applicability of Surface Act to coffee plantation or estate on the ground that the same is an agricultural land, having regard to section 31I of the Surface Act. Whether the said provision is not applicable to an agricultural land, and therefore the action initiated is illegal and contrary to the object and purpose of the provision, had to be considered. It was necessary to give an answer to such a question before concluding.
Let us look at the Surface Act.
Yes.
Where the agriculture lands are exempted.
31, section 31I.
31.
We'll read it. Hmm.
(31) says provisions of this act not to apply in certain cases. The provisions of this act shall not apply to. I will just permit to skip A, B, C, D, E, F, G, H. Then I will connect the first line with that I. The provisions of this act shall not apply to any security interest created in agricultural land. That's what it says. Now, in this background, what is an agriculture land is not defined in this act. So that's how it has arose for consideration of the honorable court.
No, whether,
Yes.
what is the intent behind incorporating this was considered when any of the judgments?
That's what the division bench has this one. In fact,
That is with regard to the state enactment and the, because it falls under the state list. That's why it is.
yes, exactly. That is point. Therefore, this matter may be taken up on Monday. I will make a brief synopsis to save the time of the court also. I will not go on arguing what I have already argued. And I will just point out from my synopsis.
So both of you file your respective
Synopsis, because this is very
like a
important,
written
this one.
argument, right? Your written argument you file,
Yes.
and only point out from the written arguments what is relevant, and we'll conclude it.
Yes.
Sometime.
Otherwise,
not on Monday, so sometime on.
Wednesday?
Yes, Lord. So I can able to.
Or Thursday we'll have it.
Yes, sir. Yes,
List it on Thursday. By the time both the councils.
Wednesday would be Thursday, Friday.
Wednesday, both the councils shall file their respective written arguments.
Ten.
Yes. Then number
Wednesday.
23, Kalyanar, 23.
The list is in that. List is.
Hearing for the respondent number 2 and 3, my lord, kindly pass over.
No passover today.
The lordship, the senior is on the way and that is why.
23. What does this matter?
My
22.
lord, in this case, my lord, the time was granted for them to take instructions and file statement of objections. Couple of times they have taken.
Have they
statement.
filed?
Not yet.
Then by passing over, what will happen? He has to file objections. That's what it is adjourned for.
We have filed wakalat only for R2, R3, my lord.
R3.
Who was directed to file the objections?
My lord, 2 and 3, bank.
Where is Mr. Vignesh Shetty?
Vignesh Shetty is no longer in that case.
You are not, who filed wakalat? 23. You appear for the bank?
Yes, sir.
Who is the counsel?
Satish Kumar.
K. Satish Kumar.
Will lecture?
Please.
So without objections, we can't, will them another, finally a week's time is granted for filing objections. No further time will be granted. Just after a week, give some date based on the number of matters. Yes. Next.
Number 24, preliminary hearing.
Lord, sir. 21.
Yes, Mr. Vignesh Shetty, where are you?
I got second, my lord,
Yes.
put 11.
Security defense.
My lord, it's a matter wherein, my lord, what is the, they filed an affidavit yesterday. They
I'm
filed a copy
filing.
Take that over.
for release of one of the property. My lord, the
My lords,
bank-
as submitted on the last occasion, within 7
Read,
days,
first let's read what has been stated.
para 2 minutes.
For necessary orders being passed by this court within a period of 7 days. Read that from para 2.
I state that upon necessary orders being passed by this honorable court, within a period of 7 days from today, I shall deposit a sum of rupees 1 crore by way of demand draft. Thereafter, upon deposit of rupees 1 crore, the respondent bank may release item number 7 property to enable me for conveyance of the same in favor of the prospective purchaser. Within a period of 15 days from the date of release of item number 7 property, I shall deposit the balance sum of rupees 96 lakhs before this honorable court by way of another demand draft. I will raise the said money by selling the said item number 7 property, and I have identified and 1.96 crores is what they mentioned for realization of this.
But why was it adjourned on the last occasion?
For this affidavit to be filed in this manner.
No, it's a fact, my lord, one of what had happened, my lord, one of the property they are seeking for release. My lord, my lord, 13-2 assailed before this honorable court, stating that, my lord, their securities, my lord, more than, my lord, what is the money which I had to recover. And, my lord, one of the property, if they release from the, my lord, bank is released, they will pay the money to the bank. That is, my lord,
Still your amount is secured because of the remaining amount, because that the properties
My
are
answer is
more
this.
than, or 2 times, 3 times.
My answer is
4
this.
times.
It is like, my lord, it is.
Hmm.
My lord, in fact, today I got an instruction from my client, my lord. We may not able to, my lord, concede in respect of releasing of the property in favor of the petitioner, even though, my lord, he want. At the most, my lord, I'll put the property for auction. Let him come and or let him bring the, because, my lord, now in this juncture, my lord, I can't release the property or I can't sell it because 13-2 only done. 13-4, my lord, 13-4, and once I issue the sale notice only, my lord, I can.
By virtue of this arrangement, if everything is, no, ultimately, what is the concern of the
Concern,
bank?
my lord, I have to
That
recover my
your
money.
Whatever the amount, whatever the properties that are mortgaged, They are now already 4 times above the amount
Full time, my
outstanding.
lord, there, my lord, I have some dispute, my lord, that time when they offered a security, that time, my lord, we took a valuation, my lord, that, my lord, now later, my lord, we are not able to identify the property.
We'll look into your valuation.
My
What is the valuation?
My valuation, my lord, in fact, that point of time, my friend might said, my lord, more than what is outstanding as on today, my lord, the valuation is that it is not in dispute. Now, my lord, I am not able to conduct the valuation because some issues in the, my lord, boundaries of the property and other
We
factors.
will go with the valuation as on that day, not now. Valuation will not, there will not be depreciation. If at all, there would be appreciation.
My lord, my difficulty is this. As long as I am not able to identify the property, I am not able to put the property for auction. Then, my lord, maybe.
You're not answering my question.
I understand, my lord, what my lords.
That day, if it is 10 rupees, it would be at least it would be 10. It won't become 1, isn't it?
I agree, my lord. That.
So we will consider the appreciation or the whatever the valuation as on the day. If it is considered, for what is the loan, outstanding loan today?
My lord, according to me, my lord, it is 9, as per instruction, my lord, 9 crore.
9 crores. And what was the valuation of the property as on the date when you have granted them the loan?
My lords, may I praise on that? As of 2022, excluding this property that they're which I'm seeking release, it was 34 crores.
And this property?
Now as per my opinion, it is 1 crore. They said 1.96 crores. I said 1.96 crores I'll deposit. As per their valuation, they said 1.96. I considered to that.
Then
I said,
why did you mortgage property worth 34 crores for 9 crores?
desperation, I can say, my lords. Unfortunate desperation, because this was a
call.
resort.
It's a business call. My lord, now, my lord, he can't make submission before this honorable court saying that, my lord, I am not aware all those things. My lord,
I didn't say
What I'll say is, now, in respect of the entire loan amount, you already have a property worth 34 crores as on 2020?
29/7/2000,
valuation.
10/9/2022.
Not somebody's valuation. As per the valuation of the bank.
Conducted by the bank.
Conducted
At the
by
time
the
of
bank.
availing the loan.
Yes, it is 35 crores. But what he says is the outstanding is 9 crores. He says, what is your case? You will deposit the entire amount.
1.96 crores within 7 days from today, 1 crore. They'll release the property, another 96 lakh by way of DD within 15 days. And I've placed it on an affidavit.
And what about remaining money, my lord, which I am entitled? My lord, lateral, so at
That
least.
they're entitled to take whatever action that, my lords, excluding this property, it is 34 crores.
Then you proceed against the 34 crores worth property.
My lord, in this application, whatever they filed, my lord, my instruction, my lord, to my lord oppose or my lord, we may not able to concede to my lord release the property. My lord may pass a necessary order, my lord, we'll do that. Or my lord, let him undertake. After releasing this property, I will undertake to deposit entire remaining money within so and so time. The difficulty is this: I'm not able to identify the property. That is, of course, my lord, it is my, when I sanction the loan, my lord, I have verified the boundaries and all. Now, my lord, some issues, my lord, we are not able to identify the property.
No. What about the remaining one? Why should no in a piecemeal basis? Why are we doing it?
My lords, my only submission is that I understand that I have challenged the demand notice. The writ petition is multifaceted. I have also sought for a requisition way back in 2023 requesting for release of this property when they declared my account as NPA. Immediately, I requested them to release this property so that I sell this property and repay the entire amount, regularize
So you
the
remain to
account.
be a defaulter even after this payment of this
I'll
amount?
take steps to regularize my account. I'll approach them because at least this property could be released so that I'm not taking any money out of it. I'm going to pay back the entire amount to the bank itself. I'm depositing it in favor of the bank before this honorable court.
Then they will do it. Why should the entire amount you are going to pay back to them? Let them sell it and do it on their own.
They will sell it, they'll undersell it. As per the guidance value, it is 70 lakhs. Guidance, the government value there is 70 lakhs. So that's why I submitted it is 1 crore. They said 1.96 crores. I'm ready to deposit 1.96 crores. It's a fair request, my lords. I'm not understanding why the bank is disputing.
Your whoever the prospective buyer
Kindly.
is ready for 1.95.
He is ready for 1 crore, my lords. I'm depositing 96 lakh from my hand.
So he is ready for 1 crore. Now they will issue the sale notice. And the property is kept at 70. What is the price? 70.
1.96 crore. 7, schedule 7.
No, he says 70 lakhs is the
That is the guidance
market value of the property.
Guidance value is 70 lakhs. I'm told that the market value is about 1 crore. They said, no, it is 1.96 crores. They said, if you match 1.96 crores, that's the submission that they made on the last writ of hearing. Accordingly, I filed an
They are
affidavit.
able to sell the property for 1.96.
My lords, if I'm ready to deposit that 1.96, and this is in excess of the security amount, My lords, now, as your honors observed,
What is the advantage you are getting? That I'm not able to understand.
at least my property will be sold on the market value, my lords. And at least my loan account will be
You also
serviced.
can't sell it below that price.
My lords, what my submission is that.
If below that price.
I can't sell it and it will be much
No,
more.
you had there, no, 1.96 is the price, the guidance value. Then above they have to sell above that, or else they've canceled the auction. They will try for another 2-3 times, then only they can do something.
Kindly.
Then what is the advantage that I'm not able to understand by doing all this exercise?
My lords, at least my property will go for full value. And at least this entire amount will go into my loan account so that my loan account becomes much smaller than what it is as of now.
Then let them issue a sale notice. We'll see if it doesn't fructify, then we'll see.
My lords, immediately.
All this exercise.
My lords, within 15.
No, at least I can understand that by giving that property is much worth than some 2 crores, 3 crores, and what you have to pay is 1.9. The remaining amount you are going to get. You are not going to get anything.
I'm not getting anything.
And why are we passing and doing all this exercise?
My lords, my submission is this. Now, as your honors observed, the loan amount is 8.86 crores as per the demand notice. Today they say it is about 9 crores. Let's assume it is 10 crores. Let's assume for the sake of arguments. As of 2022, excluding this item number 7 property, it was about 34 crores.
No.
I'm not understanding how they could hold back this. So accordingly, now out of desperation.
You are not able to understand that. I am not able to understand your submission.
Kindly.
What is the advantage your client is getting by doing all this exercise?
My lords, my loan account will be
You are not
serviced.
letting them to sell the property. Let them to sell the property. They will sell it above 1.96.
My lords, I'm only
Then that
depositing.
amount will be credited to your loan account.
I'm depositing that amount, and my lords, now they have
You
no
are not
occasion.
retaining the property, is
No,
it not?
I understand, my lords. My submission is that they could sell the other properties if they want to recover my loan. They could sell the other properties, or at least they could initiate actions. I will
This
defend
property
that
also
as.
they are selling. It is not that you are taking the property or keeping it with you. There should be something. There is something which you are not telling the court. Otherwise, otherwise, it is not in the interest of your client at all.
Absolutely, because my lords, now these are the properties that are available with me. Now my loan
It is
is.
not even your case that the bank has earlier made some attempts. They couldn't sell, and because they are not able to sell, you are made to pay the interest or something. I can understand. Even that stage has not come.
May I make this submission, my lords? Now, when my account is declared as an NPA, that is what they're saying, it's declared as an NPA. I could sell my assets. Now what I'm trying to do is that, my lords, I'll at least deposit this amount. I also have another property which is not mortgaged here. Some other property in Bangalore or somewhere else, which I'm told. I'm planning to sell that property also so that I could close the loan account without, because what happens is the other properties that they have in mortgage, I'm running an active resort there. So I do not want them to sell that property. I have to raise funds. Now this property is given as a security interest. I'll sell this property. I'm planning to sell another property, raise another 5 to 6 crores. I'm trying to clear off the entire amount. That is my intention. That's why I'm before this honorable court. Because if they sell my resort, I have invested over 50 crores on that property. Kindly.
While this court exercising the jurisdiction under 226, for passing such an order, there should be some benefit to you. And the court do not see anything.
Kindly, benefit is that, my lords, the other secured assets, my endeavor is to not touch that other security interest of the properties, because this property I am planning to sell, and I'm trying to sell another property. I'm trying to clear the loan. Now,
still there's no logic in that.
No, my lords, the question is about prejudice to the other side. Question is about the prejudice to the other side.
Not about their, how are you entitled for such a procedure? Why should the court take that kind of a stand?
My lords,
provided if you place before the court something like, if this is done in this manner, it's advantageous to you. It's a different aspect.
Because my loan account will become, now they're saying the due is about 9 crores. Now if I deposit about 1.96,
about 9 crores. Don't talk about 9 crores, which is irrelevant and which has nothing to do with this transaction.
Now it will come down to 7 crores, my lords. After this, it will come down to 7 crores.
We are only concerned with that 1.96.
Kindly, my lords.
You want to pay, you want to sell, pay 1.96. They also want to sell and appropriate it. So why should the otherwise procedure be adopted? There should be some reason for that.
I understand.
I don't find any reason.
If my security interest was to the loan account, I mean, in the sense that if my security interest was about 10 crores, I would have not made this prayer at all. If my security interest is
still you are not answering. You understood what is my query.
No, I understood, my lords.
But I'm not able to understand the what is the connection and why do you want to do it this way?
May I show some citation on this matter?
For what?
On the earlier occasion also, similar, at least some similar prayer was
There won't be
allowed.
any citations. There won't be any citation of that nature. It's completely, first of all, the discretion that is exercising by this court itself is something. So there is no law on this.
Well, I absolutely understand. Now we are before your honors and we are in your honors hands.
No, that's what.
This is a
I
bona fide
want-
intention of a borrower to pay back the
The
amount.
court has to deviate from its usual stand and do something. It should be beneficial either to you or to the bank. It is not beneficial. It is like, you are not, why do you want this? I'm not able to understand.
Because my lords, now if they have now the option.
Please don't tell the same story again.
And no, I'm not saying
Only
this.
to my query. Whether you sell it or the bank sell it, what is the difference? Bank is not selling it less than what the guidance value is.
No, not the
And you
guidance.
are also selling it at the same price. Why should you sell it? I can understand that I will keep it. I will keep the property and I'll pay to the bank is a different submission. And we will say that he is ready to pay. You take the money and release the property. But
Kindly,
that's
my lords.
not.
I'll do
But
that.
you say I will sell the property to somebody.
My lords, in that case, the property may be released in my favor. And 1.96 crores, I'll deposit it before the court.
Deposit. If you deposit, what is the difficulty to them?
Kindly, my lords. I hope that is not a problem to them at least. I'll deposit the
Guidance value, you have kept it as 1.96. Let them pay the money, you release that property.
Kindly, my lords. And later it is for me to either sell it or do whatever. At least I'll keep the property for this.
When will you pay? Once you pay, then only it will be released.
Now, in this, I've taken 7 plus 15 days. So same timeline, 20 days.
I'll keep this writ petition pending.
It may be parted also, my lords.
I'll keep it as a parted.
Kindly.
Once he pays the amount, then you can release that.
Kindly.
Even on the last occasion also, that's what I've suggested to you.
No,
So
sir,
file an
I
affidavit of
understand.
that nature.
I'll not say that. I understand.
The land council, appearing for the petitioner, submits that the total 7 properties are mortgaged to the bank, and 6 properties are worth 34 crores as per their valuation.
As of 2010.
2022.
As of
And this property, subject property, that is the 7th item of the same. Now, according to them, it is the guidance value that's fixed by the bank is 1.96 crores.
Market value, my lords.
Market
value. Market value as
Market
per
value
the
is
reserve price.
1.96 crores. It is submitted that the petition is ready to pay the same. And once, after paying the same, the said property may be released to the petitioner. Considering the fact that the outstanding is 9 crores and all 9 crores with respect to the 6 properties that are mortgaged, and the value as on the date is 34 crores. And the fact that the petitioner is ready to pay the amount within 15 days.
20 days.
Within 20 days from today. Within 20 days from today, this court deems it appropriate to pass the following order. Once a petitioner pays the amount of rupees 1.96 crores within 20 days from today, the respondent bank shall release said mortgage in favor of the petitioner. Listed as part heard after reopening.
It will, my lords, order may be kept as is. This 20 days time, I'll just take one instruction from the client.
You tell the court officer that, and him also.
Kindly.
Passed over matter. Swaroop 21, isn't
21.
it?
Great. I'm great.
Yes, next. After vacation. Parted. Yes, next.
24.
My lord, the 24 has become infructuous, does not survive for consideration.
Then counsel the petition submits the writ petition has become infructuous. Accordingly dismissed as infructuous.
Till number 25.
Lord, I undertake to appear for the respondent. My lord, may kindly permit me to appear online. In serial number 25, my lord.
Yes.
Lord, the sale has already taken place.
Impute notice dated 21/1/2006.
The sale action has been made in 32
And
to
the terms and
26.
conditions say will so and so. Union of India, so and so, not to issue sale certificate. Why
Your
have you come
sale-
before this court?
Actually, one thing, because the value of the property is.
So whatever it is, why should you come here? Why not DRT?
Because my lord, the already sale action has been made, Your Honor. For the value of the property is 3 crore 92 lakhs, my lord.
Whatever,
Yes, my
whatever.
lord.
There should be an exceptional reason that you are coming here.
Is there, my lord, DRT?
What is that?
Because my thing, one thing, my lord, the value of the property is 3 crore 92 lakhs. The
Oh,
only
that's
the
a
action
fact.
made in
It is a
86 lakhs.
fact. It is a fact. That factual aspect will be decided by the DRT. Why should we invoke the jurisdiction under 226 in this manner? And already sale is completed.
Sale
Go before the
certificate also
DRT.
issued.
The writ petition is filed, seek the following prayer. Then counsel the petitioner submits that the bank, when the property of value of the property is,
3 crore 92 lakhs, ma'am.
well, then what did they do? What is the value?
Against that
No,
value,
it is
only the
sold.
86, they sold
And
86
the property they are going to sell it for 86 lakhs.
86 lakhs.
86 lakhs, and the petition has come before the court. Then counsel appearing for the respondent bank submits that the property is already sold on
My lord,
13
sold
to-
on 13/2.
for an
And
amount of,
my lord, for the amount of 86 lakhs is one property. The other property is 1 crore, my lord. Two properties were there. Both the
two
properties
properties, one for 86 lakhs and the other property is sold for 1 crore.
Yes.
The next, having
Sale
heard the
certificate
counsel,
also issued, my lord.
and a sale certificate is also issued. Consider having heard the counsels on either side, because the material on record. When the when the borrower is aggrieved by any of the proceedings that are issued, when any party is aggrieved by the proceedings initiated with the Bank and the Surface Act, the remedies are available to the parties to go before the DRT. If he is coming forth this court under 226, the petition has to the convince this court what are the exceptional reasons why he is seeking indulgence of this court. The reasons that are stated by the petitioner are not the reasons on which this court shall exercise the jurisdiction. Hence, this court is, and also the fact that the sale has already taken place and sale certificate is issued. In that view of the matter, this court is passing the following order: that the petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy. Same section 14.
Let them serve a copy of the writ petition. My colleague is there. ma'am.
Divya Purandar, give them a copy. Divya Purandar appears for the respondent. Yes, next.
Great.
Cell number 26. Cell number 26.
For the petitioner,
Advise.
that section 14 order for taking possession.
Asset reconstruction company, it is not maintainable. The writ petition is filed against so-and-so in the light of the law laid down in Vishwabharati, so-and-so. The writ petition against asset reconstruction company is not maintainable. Accordingly, writ petition is disposed of liberty, section 14. Yes, next.
27 and 28. Cell number 28. Government advocate K. Rajshekar.
State writ, my lord. Annexure A is under consideration. It's an order passed by the state commission where the R2 has filed an application seeking certain details.
Against that, there are appeal lies to the no appeal provision.
No appeal, it comes to writ only. Writ is maintainable under the right information.
Let's take that.
Right to
Right to
information. Act.
Information Act.
Lord, appeal lies under section 19 subsection 3 of the Right to Information Act before the Karnataka Information Commission against an order passed by the first appellate authority.
All the books have to be there. No, look at the roster and ask the library people to have all the books.
Madam,
Not about telling, you should ensure that it is there. If not, you call them. We can't be searching for the books. You're referring to
19 subsection
19.
3, my lord.
section 19.
Yes.
ಇಲ್ಲ ಕಲಿತಿದೆ ಒಂದು ನಮ್ದಿದೆ ಸರಿ ಇಲ್ಲ ಬರ್ತಾ ಇದೆ ಸುಮ್ಮನೆ ಮಿಸ್ ಮಾಡ್ಕೊಂಡು ಡೇಟ್ ಹಾಕೊಂಡ್ಬಿಡೋಣ Order is it commission only. There is no further. Kindly the operative portion is Lordship kindly see page number 23, my lord.
Yes.
20 of the order portion. The information which was sought by the respondent number 2. Page number 22.
Page number 20.
20 of the annexary. Crime was registered at Karwar of a person who killed under section 302 of the IPC. Subsequently, that particular crime was transferred from Karwar police station to the CID. The investigation was continued there. This respondent number 2 made an application to the CID seeking these information. May I permit you to read that?
Amount spent on the investigation team.
Yes, amount spent on the investigation team journey to Dubai and back to the investigation. Amount spent on the TADA for the investigation officers who went by flight to Delhi, Lucknow, and Mumbai. Amount spent on flight charges for the superior officers who supervised the investigation at so and so. Amount spent on the fuel for the vehicles used by the investigation officers. Amount spent out of the secret service funds towards the investigation. The response from the state commission is that this is a exempted information under section 24 of the Right to Information Act. That it was denied. Again, that particular aspect was considered by the respondent number 1, where he says that no.
So why it is? What will happen if this information is declared?
Well, we say that
Nobody is asking you about what is the investigation, what have you done? Nothing. No, you are spending the public money in the process of doing some investigation. If somebody asks what is the investigation, who did that, who did this, which place you have visited, and it's not. No, you don't have to, but you have spent public money. And under the guise of this investigation, if somebody has an information that you are abusing your position and spending the money, what is the wrong in it?
The TDC section 24.
Yes.
24 says it.
Let's read 24. Act not to apply in certain organizations. Read.
Nothing contains also. Provide 24(3).
What did it say? 24(3).
3. Not 24. Nothing contained this act shall apply to the intelligence and security organization specified in the second schedule, being organizations established by the central government or any information furnished by such organizations to the government.
No, you read the starting, 24 starting.
That's why nothing contained in this act shall apply to the intelligence and security agencies.
Read it further.
Specified in the second schedule, being organizations established by the central government or any information furnished by such organizations to the government, to that government, provided the information pertaining to the allegations of corruption and human rights violations, so and so, provided that, my lord,
Shall not be excluded under this subsection.
Subsection.
Oh,
This
what
one that-
what has been sought for by the petitioner, by the applicant, is nothing to do with any of your intelligence operations.
my lord, why the notification, there was this particular CID, the investigation was conducted by the CID. This particular CID institution was exempted under section 24(1) of the Act.
Where is that notification? After he filing the application or
No, no,
before?
it was much earlier.
Where is that? Where do you get it?
Annexer J,
Page
page number 73, my lord.
Yes.
74. In
This
exercise.
is issued on 5/12/2005.
Yes, ma'am. 6/5/2013. The typed copy, lordship will get it in page number 75. In exercise of the powers confirmed by section 4 of subsection 4 of section 24 of the Right to Information Act, so and so, reduced section 21 of the General Government, the government of Karnataka hereby proposed to make amendment to the notification so earlier. In the notification after serial number 2, the following shall be inserted, namely Criminal Investigation Department, CID. Once it is exempted by virtue of notification under section 24, this information is excluded from furnishing to the petitioner, the respond number 2. Earlier notification, lordship will get it in page number 73.
Every notification issued under subsection 2 shall be laid before each house of the parliament or whatever the state legislature. Was it late?
That information I don't
That
have.
is also required. By
If
just
it is-
giving,
if
and
it-
now,
If it is not
this-
tabled, then ultimately.
no, it will
goes,
go,
it goes.
you will not have any,
It goes.
no, but the whole thing is, we can, the whole purpose of this particular 24 is where the sensitive issues with regard to the intelligence and security organization, that is not required to be revealed or it is not amenable to Right to Information Act. Here, what is the difficulty in telling the amount? It's a public money spent. Nobody is going to, no special, nothing will, it will not hamper the investigating process or anything, nothing will happen.
And even Malad, to that extent,
No, no, for to say that a particular information cannot be given, there should be some reason.
only by
Unless and until you have your own vested reasons for not to disclose. Maybe if somebody is asking for that, there is a reason for it.
maybe only the defense of the state is that it was exempted by notification issued.
The learned AGA, relying on page number 74, Annexure J,
74.
70?
72.
72 and 74, submits that the government of Karnataka has issued a notification dated 6/5/2013, whereby the criminal investigating department in police department with criminal investigating department within brackets CID, in police department within brackets investigation intelligence report are added and then are exempted as per section 24. The writ petition is silent about whether as per section 24(3), the notification issued under subsection 2 is placed before the house is not forthcoming in the entire writ petition. Further, whether when the act is very clear that the information pertaining to the allegations of corruption and human rights violation shall not be excluded under subsection 24. The petitioner in this writ petition has sought for the information with regard to the amounts that are spent by the special investigation team. And this court, prima facie, is not able to understand why that information cannot be disclosed. Hence, the respondent, the petition, the AGA shall place before the court whether shall place before the court the following information. One, whether a notification as contemplated under section 24(3) of the Right to Information Act 2005 was placed before the house, before the house. Number two, whether this information pertains to any intelligence or any security issues of the state. Let's this matter on 23rd of April.
Bill number 29, Rupesh B for petitioner.
Yes,
Milord,
Oh, you moved the memo. Why?
Milord, under the Senior Citizen Acts, Milord,
Uh.
the release date was came to be, Milord, cancelled. It was executed.
Come to the cause title. What is the relationship between the parties?
Pannigoda is the son of Milord, the respondent.
3 is the father.
No, Milord, the 3 is the.
Respondent number 3 is the father.
Mother.
Timmamma, yes, mother.
Vairagoda is the son.
Baraguda is the son.
Second son.
You are?
I'm the first son.
Who are you? First son. What is the order of the authority?
Authority, Milord, cancelling the Milord, the release date.
Cancel the release date.
Release date.
What is that release date?
Release date, Milord, the mother and the Milord, the daughter have released their right.
In favor of the son.
In favor of both the sons.
Both the sons.
In favor of both.
When
the
was
sons.
that release date?
23/4/2014 for consideration.
23/4/2014.
4/2014. It is for consideration.
How much is the amount?
40,000.
40,000.
No, Milord, at the instance of Milord, fourth respondent, Milord.
When was this? When they have approached the authorities?
Milord, they have approached the authorities, Milord, in the year 2018.
What is their case before the authorities?
It is their, the mother case is that, Milord, I am not looking after. There is no allegation against Milord, fourth respondent. Fourth respondent, Milord, instigate.
No, she says, I've released my right and you're not taking it. Then why do you, she has taken money?
Taken money. Taken money, and you have also stated before the authority
Yes,
that
Mr.
we are
AK.
ready to
Will
give
it-
maintenance.
Yes.
Once the release deed is executed.
That is the
with
consideration.
With consideration. May not.
For cancellation of it, they have to go to the civil court.
The Assistant Commissioner may not exercise under 23. And the word is
I
given
abstracted to 23.
or otherwise. Maybe the phrase under section 23 is gift or otherwise. The release deed may come under the ambit of or otherwise. But once there is a consideration, it may not hold the test of the.
No, my lord, so
You
far.
appear for whom?
By reading, I am appearing for the respondent number 3, mother of the petitioner, my lord, Timmamma. Interested by the,
What are you doing from 14 to 18?
interested by the High Court Legal Services Committee, my lord.
And doing the pending, and I have filed a memo.
But unfortunately, this commission is also doing the things which are not within their purview, within their jurisdiction.
By reading, my lord, release deed, so far it is not forthcoming whether she has received the said amount of rupees 40,000 by way of cash or by way of check. Nothing has been stated here.
Now the issue is, it is nothing pertaining to her welfare. She can seek maintenance from the son, but she cannot say that it has to be cancelled. It's a registered document.
Well, after cancellation of this deed, Milord, mother has executed, Milord, gift deed in favor of the second, fourth respondent. That I have placed before this court.
No, it's
I have
not.
filed memo.
Then what should happen to that? No, this repetition is allowed. Then what will happen?
That will also go, Milord.
Huh?
That will also go.
No, that will not go.
How it will go?
That will not go. That is
It's a registered
separate
document.
That is the motto, Milord. That is the motto by the fourth respondent.
No, let's forget about the motto. Forget about the motto. What is that? What will
Basis
happen?
of, Milord, this petition, I may, Milord, I seek for declaration before the
That we have to observe because no, the registered document, where will it go?
That, on that basis, Milord, I have to seek. Or
Yes.
otherwise, Milord, it has fallen to the share of a fourth respondent, sir. The adjustment will be made. Fourth respondent has also.
So
got a share.
now we are only concerned with what is the effect of this order, and in the light of another deed being executed, what should happen?
There is a
So
proportion
this
of-
action would be bad. Then you have to settle both your claims before the competent. Yes, disposed of. I'll dictate it later. Yes, next.
Till number
Call the rest.
30,
That is maintenance is ordered, except
Huh?
maintenance, nothing under that.
Maintain, no money,
Senior Citizen Act, 2,000 rupees maintenance is ordered.
not just that.
In which case?
30, my lord.
No, no, in that case, the maintenance is granted.
No, under that, there is no maintenance.
Judgment. Yes.
My lord, serial number 30, my lord. This I am the wife and the two daughters of the respondent two who had filed for a maintenance application before the Senior Citizens Tribunal. And the annexure E is the impugned order, my lord.
Come to the cost rate.
Aside, my lord.
Page number 5.
Page 5. So that one submission, my lord.
Who is this Basva Chetty?
My lord, he is my husband and petitioner number 1.
Petitioner number 1's husband.
And petitioner 2 and 3's father.
Where are the senior citizens?
He has claimed he is a senior citizen and has filed an application.
No, as
before
per, who is a senior citizen as per the act?
the 60 above.
60.
None of them are senior citizens. Where from this act has application to them?
Exactly, my lord. That's my first contention. How could the impugned order have been passed when at the time of that he was 59 years old, admittedly, and we have his election ID and everything to show his date of birth is 1962. So at the time of application in 2021, he was 59. He would have turned 60 only in 20.
What about notices to the others?
My lord, it was unclaimed, and on 2023, my lord,
Health
the
official.
Honorable Court had said it can be taken as deemed service. And an interim order was passed. We have complied with that interim order. My point, my lord, is this.
What is the interim order?
Interim order is that we had to deposit 44,000 rupees before the High Court. We have done that, my lord. As per the impugned order of 2,000 rupees per. Second point, my lord, is that it is not even maintainable against petitioner number 1. I'm not an elective as per the act.
Petition
Wife.
is.
Wife.
Your Lordship is disposed.
Yesterday I passed one order.
2 and 3 are
Red
not
petition is allowed. The amount in deposit shall be refunded to the petitioner. Order follows.
My lord,
Yes.
one submission. The council name may be changed because he is now additional SVP.
Yes.
My name.
Yeah,
For the petitioner, so and so.
Petition number 31.
No, it's appearing for the petition.
Rajashekar.
Yes.
Sri Rajashekar.
In this matter, entire amounts are paid. Notwithstanding that, the property documents have not been released from the respondent bank owner. Let's kindly see.
Who appears to the bank? Mr. Muttana.
Yes, madam. My lord, that their prayer, your lords may kindly see. They want this original documents to be released. But the
That
bank.
you are not a borrower.
I'm a borrower.
Borrower only. Then only they have to pay the money because now according to the bank, my lord, now your prayer, your may kindly see, my lord.
What is the amount according to you that is
18
outstanding?
lakhs 92,000 rupees plus interest. It may come to 19 lakhs, 19
Is the outstanding according to?
outstanding according to the bank. And after paying that money, they will pay, release the documents and pay you no due certificate. That is the usual procedure.
Kindly see, my lords. Because there was
No,
a.
that dispute, that arena will not enter. Whether what is the amount, what is due and all.
Kindly see page number 20, my lords. They have sent out a communication on 9/12/2021 stating that I have not adhered to the OTS. However, they have taken all the monies from me. In the last paragraph, in the view of the pending approval of waiver of penal interest, 20 lakhs and 20.82 lakhs, we request you to pay remaining dues 17 lakh 42,524 on or before 14 December to avoid continuous action under the surfacing. Fellows, the next 21 is a statement produced.
One minute. When did you pay?
Fellows are paid by 14/12/2021. The statement is produced in annexure E, page number 21 to 24. The entire, I have paid 17 lakh 43,000.
Yes.
Entire amount is paid as
No,
per
my
the
lord,
demand, my lords, and now they approbate and reprobate.
My lord, their prayer is,
Forget about their prayer.
no, that is.
Look at, no, please first listen to the court.
Yes, ma'am.
Page number 20, what is this amount
Page number 20.
of their merit petition?
My lord, page number 20, this 17 lakhs 42,000, 524, as on 21. Now they are telling 19 lakhs. Don't pay comes. 19 lakhs, 93,000. Their prayer is penal charges has to be waived. Normally that even that is not possible. Next, legal charges should be waived. Next, another one more, that whatever money paid to them, it has to be waived. That how it is possible? That is
So
the
the
prayer.
pending approval of for waiver of penal
That
interest.
they put up.
After that, when did you communicate to them
That
that
is
the
my-
request for waiver is rejected?
Page number, that is again, that letter is last letter, my lord. That is page number 30. Letter dated
Now, after that.
29th January 2022. Letter dated 29th January 22, Annex RG, page number 29. There they have explained, my lord, that exactly last. This page number 30, para 3. Further, please refer to your letter of a commitment handwritten as well as a stamped agreement signed by you dated 30/11/21, wherein having a lengthy meeting discussion after you committing to pay back the balance amount due as per the loan account statement of rupees 38,14,024 with the incidence of present and future interest and expenses, charges and also and so. Next para. Now, instead of adhering to the terms of the agreement accepted by you, you are raising the issue of waiver of penal interest and charges at this juncture is not acceptable to us. Please note that the penal interest that has been charged is as per the terms of the sanction of the facilities to you, which has been duly accepted by you.
According to you, that 18 lakhs is a penal interest.
That is all. 18 lakhs is the interest, penal interest, legal charges, and that commission that they have mentioned all the three. It becomes to 18 lakhs.
And now this writ petition is filed in 2022.
Yes, my lord.
Have you filed your objections? Have you given at least a piece of paper when they say that we have paid entire amount and now you're not granting? Are you not supposed to file your objection or say that this is the statement, as on the day, this is what it is, this is the interest that has accrued?
And Monday I'll file the statement. Monday.
Does this matter on Thursday? By the time the counsel appearing for the bank shall place before the court how they have arrived at an amount of rupees 18 lakhs.
Yes, ma'am.
And odd, whatever is the outstanding of amount, how they have arrived at that. And before that, before Thursday, a day before, the statement shall be given to the counsel for the petitioner.
Yes,
Number 32, as Shishidhara. Acharya for respondent.
If I may submit my last date of hearing, he said he'll file an affidavit with regard to how he is going to close the bank account, loan account within 3 months. That affidavit is being filed.
Yes. Take that. This is outstanding balance within 3 months.
As on today, the outstanding balance is around 27 lakhs.
27 lakhs. That means how much he has to pay?
27 lakhs he has to pay after deducting this, whatever the amount is being paid previously. As on today, 27 lakhs is outstanding.
That's what I'm saying. 3 equal installments, I'll say.
Please.
As on today, the outstanding is 27 lakhs.
Please.
He shall pay in 3 equal installments. In the last installment, you should inform to him any amount that is any incidental expenses or whatever it is, you can inform. The writ petition is filed. The writ petition is filed, saying the following prayer. When the matter came up on the last occasion, as the petitioner has submitted that he is ready to pay the entire amount, this court has directed the petitioner to pay the undertaking affidavit. Today, an undertaking affidavit is filed stating that the petition is ready to pay the entire amount, clear the entire outstanding amount within 3 months. Within 3 months. Learned counsel appearing for the respondent bank submits that. There shall be, this court may impose the conditions in case if there is any default on the part of the petitioner. Considering the same, this court is passing the following order. In the light of the undertaking affidavit filed before the court, the petitioner shall pay the entire outstanding amount within 3 months from today. That what is today? Today is?
2nd of April.
That is?
May, June and July.
By third, May, June, July. By 3rd of July, the entire amount shall be paid. Next, number 3, the bank before the 3rd installment shall inform to the petitioner if any interest that accrued on the amount, and the same shall be paid. If the petitioner fails to pay even the first installment, the respondent bank is at liberty to proceed further. Next, for filing an affidavit and not, if the petitioner fails to honor any one of the conditions of the affidavit, he shall pay costs of rupees 1 lakh to the bank.
May I make a
Huh?
question? 3 months time. My submission is this, my lord. My amount is struck by the BDM, my lord. My property is acquired.
Affidavit is filed, no more submissions.
Right, my lord. That 1 month installment may be, my lord. Within 3 months, I will deposit the entire amount.
What 1 month? I said 3 months.
3 months, my lord. But first, my lordship fixed the first invoice in first month.
He said May, June, July, 3 months.
Within 3 months, I will deposit. But my lordship said, my lord, if any one installment is failed to deposit, my lord, that first month is not difficult to me.
Equal
because
installments you have to
my
pay.
land is acquired by the BDM, my lord. So I am going to get the compensation from the BDA. I am also filed
You have to pay,
petition.
you have to pay within 3 months in
Within
3
3 months, I will pay, my lord. The condition regarding each 1 month installment, 3 installments, my lord, is not difficult to me, my lord.
He is ready to pay by 3rd of July. Remove the other condition, 3rd of July. If the petitioner fails to pay the amount by 3rd of July, the bank is at liberty to take appropriate steps. And if he fails to pay the amount on 3rd of July, he has to pay 1 lakh as cost to the bank.
Please, publish.
Let's see, what are the other matters? Call it.
Cell number 34, 33.
May please lordships. Item 33, my lord.
Yes, sir.
Hearing for respond number 5.
Item
Yes.
33, I am for the petitioner, my lord. So this writ petition has been filed for adequate and genuine compensation to the petitioner who lost his wife and son.
Who moved the memo? Who moved the memo? If you have moved the memo, you should have come to the court to argue the matter, final hearing.
Yes, I am appearing, my lord, but due to some difficulty, I am not
Then
appearing
come some
physically.
other day. Then come some other day. List this matter on
But take
21st.
instruction from the other side respondents, my lord.
21st
Very
April.
crucial case.
For some of the
Cell number 34.
21st April. Yes, 34.
34.
Yes, my lord. What is the date?
25th. It's a sitting day.
25th.
Sitting day. April 25th.
All right.
25th is Saturday.
That's a sitting
Working day.
Yes.
Yes, 25th we'll have.
Yes.
Yes. Not for us. Yes, next.
Cell number 35, 34. For
34, my
petitioners,
lord. The petition now does not survey for consideration, my lord. The petition is closed, my lord. On the basis of the, my lord, is kindly see the prayer, my lord.
Please give it. Does this matter according to the, what is the relief page number?
Page number 6, my lord. Directions to the respondent number 3 to take action
I
against the
don't
persons.
find the prayer.
Lord,
No
bottom, my lord.
prayer sought. Oh. The petitioner so directing respondent number 3 to take action against the persons who created the sale deed in the name of so and so.
Yes, my lord. The suit was filed. Suit was filed by the original owner, my lord. That was decreed.
Connected.
The petitioner here in my lord is claiming as a cultivator, my lord. He challenged the judgment and decree. That appeal was also dismissed, my lord. Now, my lord, he claiming he is seeking, my lord, to register a case against the original owner on the basis of the recommendation given by the Tahsildar, my lord. It cannot be, he cannot recommend to register the case, my
The
lord.
writ petition is filed.
Our contention is that the sale deed has been forged, my lord.
It is not
I was
forged,
the
my lord.
cultivator. I am in the possession till today.
He has no right, my
The
lord.
judgment
When you
is
have filed a
against-
civil suit, what
Yes,
has
my lord.
happened?
My judgment is against me, my lord, but till today I am in the possession. And the judgment was against me based on the sale deed, my lord. The impersonating the original owner, the sale deed has been.
The writ petition is filed seeking the following prayer. If the police have not registered the complaint, the petitioner ought to approach the magistrate by filing a private complaint. And this writ petition is filed in the year 2023. This court do not find any reasons to pass any orders in this writ petition. Learned counsel for the learned AGA submits, the learned HCGB submits that the civil suits are pending between the parties. In fact, the petitioner has lost the civil suit. Be that as it may, if the petition is agreed by any inaction, he has a remedy to approach the magistrate for filing a private complaint accordingly disposed of. Is certified.
Till number 35. Till number 35.
Corresponding this matter.
Then Kumar.
As per the interim order dated 14/2/2024, the petitioner paid 2.5 lakhs. Rupees.
There is
Thereafter-
no representation on behalf of the, don't write no representation. The counsel for the respondent is present. This is matter on 8th of April. Yes, 36.
Number 36.
Nothing for petitions.
Narendra.
Distress matter for acceptance of order. Distress matter for acceptance of affidavit. Yes,
He wanted instructions.
Lords, the outstanding is 40 lakhs and 93,000, my lords.
40 lakhs?
93,399, my lords.
Whatever the outstanding, I'm going to raise the deposit within 3 months.
Give that. Where is the undertaking affidavit? Yes, given it the other day. The writ petition is filed, seeing the following prayer. Extract the prayer. When counsel for the matter came up on the last occasion, submitted the petition is ready to clear the entire outstanding amount along with the interest based on the interest within 3 months. As a matter, hence this court has directed the petitioner to come up with an affidavit. An affidavit is filed dated 26/3/2026. It is stated that the outstanding amount is 39,44,407. Land counsel appearing for the bank submits that the outstanding is 40,93,390.
9, my lords.
399, and the petition is ready to pay the outstanding amount within 3 months. And on such a payment of the amount, the clearance certificate may be given, and the return of original documents may be returned to the petitioner. The land counsel appearing for the respondent bank submits that the petitioner has failed to pay the amount and is enjoying the interim order
Please, ma'am.
from a long time, considering the fact that the petitioner has filed an undertaking affidavit and is ready to clear the entire amount. This court is passing the following order. The petition is disposed of, giving liberty to the petitioner, directing the petitioner to pay the amount as per the undertaking affidavit by 3rd of July. By 3rd of July, if the petitioner fails to pay the amount, the respondent bank is at liberty to proceed further. 3. Having filed an undertaking affidavit before this court, if the petitioner fails to honor the terms of the affidavit, the undertaking affidavit, then he shall pay an amount of rupees 2 lakhs towards costs to the bank.
And after the receipt of the amount, bank will permit it, given the petitioner liberty to return the amounts, return the documents.
Once the entire amount is paid, the bank shall return the documents.
That's the amount would also include the interest, what would be for the.
Then you should include before on if any interest that accrued within that within but 3 months, the same shall be indicated to the petitioner and he shall pay. Yes.
Party, yes. 37.
Petitioner, my lords.
Give the file.
Challenge the possession notice, my lords, at annexure F. Said for your possession notice, my lords.
Housing finance.
Let's.
Finance company. Respondent.
Please, my lord. LIC housing finance.
Who is appearing?
Sri Kumar Singh.
No representation on behalf of the respondent. This is matter on that 25th, the date that you give that working day.
25.
Yes. 38.
Till number 38.
Let's.
Undertaking affidavit is filed.
Yes. Have you given him a copy of it?
Please.
Shall we record that?
My only request, my lords, they have said 31/5 and second installment on 31/8. We have no objections for the second installment. Instead of 31/5, if we could make it at 31/4, my lords, that is only the request of the bank.
Hardly 1 month, my lord, I'm asking for.
Yes, give that.
The second installment, they have sought for 31/8.
Affidavit.
Filed in the court.
The petition is filed with the following prayer. When the submission is made that the petition is ready to clear the entire amount, this court has directed the petitioner to file an undertaking affidavit. An affidavit dated 16/3/2026 is filed. As per the same, it is stated that that the petitioner has paid a sum of rupees 26 lakhs on 26/2 and a further sum of rupees 25 lakhs on 28/2, and he has paid the 50% of the outstanding amount. It is stated that the 25% of the outstanding amount will be paid on or before 31/5, and the remaining 25% of the amount with accrued interest shall be repaid on or before 31/8/2026. Then counsel appearing for the bank submits that instead of the first installment on 31/5, he may be directed to pay on 31/4/2026. Next paragraph. Considering the undertaking affidavit filed by the petitioner, this court is passing the following order. The petitioner, as per the undertaking affidavit, shall pay the 25% of the outstanding loan amount on or before 31/5/2026, and the remaining 25% of the amount shall be paid on or before 31/8/2026. Next, any one of the installment is not paid, the bank is at liberty to proceed with the matter. Next, if the petitioner fails to honor the conditions of this, fail to honor this undertaking affidavit, he shall pay an amount of rupees 1 lakh towards costs the bank.
Look, there's one small typographical error. Instead of 26/2/2026, it is 26/12/2025.
That amount he has paid, no, instead of 2, it should be 12.
The
26,
second
12,
part
20.
is correct.
Yes.
Millards, one submission, Millards. Serial number 37, Millards, interim order to continue.
37, if interim order is there, extend. Yes, next.
Serial number 30, 39,
For petition.
29.
Next week, my lord.
Next week, next 40.
Serial number
Your
40.
Lordship, the petitioner is enjoying an
Oh, is this the case? Why you want 1 week?
Eye surgery, my lord. He could not present today, my lord. Therefore, next week, my lord, I will present.
Matter
How the
taken up on
petition
Monday,
surgery is
Lordship.
concerned with the order? He is not going to come and argue.
You have to file a undertaking affidavit before this court, my lord.
This is matter. Hello, we'll accommodate. This is the matter at the request of the counsel for the petitioner on 10th of April. By that time, if the undertaking affidavit is not before the court, the writ petition will be dismissed.
Interim order may be extended.
Interim order only granted is extended.
Serial number 40. 40.
13/2, my lord, assailed before this honorable court and seeking direction for, my lord, one-time settlement offer.
Is this matter on Wednesday? Yes, next.
30, 41, 42, urgent 43. Serial number 43.
We'll hear it on some other day.
Yes.
Yes.
Maybe after vacation.
After vacation.
Challenge
Yes.
to.
30 days. 30 days, that day I took instructions in serial number 21. 30 days will deposit.
From
today,
today,
madam.
30 days.
From today, 30 days will
Then
deposit.
the date would be, that's on May 2nd.
Kindly.
May 2nd.
Within May 2nd. I'll deposit a
May
DD.
2nd, that matter. 21. Huh? No, to pay the money.
No, I'll deposit, it may be relisted after.
21st. No, 21st matter, I heard. Passover matter.
Time for deposit.
Yes, the date he shall pay within 30 days. That is May 2nd.
May 2nd. Grateful.
Yes.
Lord, any date may be given for the matter.
After vacation, any date. Reopening date maybe.
He'll be ready to ask for a date. Yes, next.
43. Jayas, Jayasimha.
That's what, after vacation.
After
vacation.
If look at it, if interim order is there, extend.
No interim order.
If it is there, it will be extended.
Serial number 46.
No, all dismissal matters fall on the 28th of
49 on though, my lord, it's a matter where 14. 49.
49 is also in dismissal hearing for
48. You're there. 49. Yes. What matter?
Lord, I have challenged the order dated.
I think you have. You said that something. She said the other day, some judgment or some.
I was unable to
My
because
lord,
I'm.
I'll just point out.
Because you are unable to, because there is no judgment.
My Lord, when I met with an accident that day when I submitted.
So what to do now? What is to be done?
In fact, my lord, their essay pending before the DRT. I'll just point out, my lord. They filed I sold a property. They challenged before the DRT. One second. I'll not take in 10 seconds, my lord.
Monday.
That matter pending before the DRT. And my lord, they came.
No time for us.
Monday, Nanilla. I am not there, my lord. We have it on Wednesday.
Is 49.
With Lord's leave, my lord, 46, my lord. Number 46 has become infructuous, my lord.
46 who appears?
But I am the respondent number 1, my lord. It has become infructuous, my lord.
Yes.
Yesterday, the matter was listed, my lords. Petitioner was absent yesterday also.
No, you are also for the respondent.
Yes, my lords. I represent Viresh Alpudia.
Oh,
Please.
let it continue on Monday?
Please.
On the same caption.
Please, my lord.
Because it's already 1:45, we can't
Please,
discuss it now.
please, my lord.
1:48.
Please.
Is 47?
Great.
Yes, this also on that 25th. Yes, 48.
48, virtually it has become infructuous. We have show cause notice for challenge. Order is passed.
We'll have it on Monday. 48 on Monday. Yes.
Passover.
And the Passover matter,
Number 12, Passover.
advocate is not there.
I appeal for the
List is-
petitioner, my lord.
Yes,
May finally question witness.
Huh?
Witness.
a witness. You have found the para? Signatures? What is that?
Which serial number?
What is that? IAM. What happened? They don't have an advocate?
ಇವತ್ತು ಲೀಸ್ಟ್ ಆಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ.
ಇಲ್ಲ 70T is not there. ಅಲ್ಲ ಇವ್ರೇನ್ ಕೂತ್ಕೊಂಡು ಏನಾಗಿದೆ ಅಂತ ಕೇಸ್ ಇಷ್ಟ ಆಗಿದೆ ಅಂತ
ಕೇಸ್ ನಂಬರ್ ಹೇಳಿ ಗೊತ್ತಾಗುತ್ತೆ.
ಅಲ್ಲ ಇಲ್ಲ ನೀವೇನೋ ಇನ್ಫಾರ್ಮೇಶನ್ ಇಲ್ದಂಗೆ ಬಂದ್ಬಿಟ್ಟು ಎದೊಳವಾಗಿ ಮೇಡಮ್ ಸಬ್ಮಿಟ್ ಮಾಡಿಲ್ಲ ವಾಟ್ ಮೇಡಮ್ ಇನ್ಫಾರ್ಮೇಶನ್ಸ್ ಅಲ್ಲ ನೀವು ಅಟ್ಲೀಸ್ಟ್ ಯು ಶುಡ್ ರೈಟ್ ಇಟ್ ಆನ್